May I please? And
Yes.
item number 3, my lord, I may be allowed to withdraw the same with liberty to file if some important document could not be annexed, my lords. In item number 3, my lord.
You're Mr.
AHMR Chaudhary.
Okay. Who's for the other side? Mr. AHMR Chaudhary, learned counsel for the petitioner, submits that. As some relevant documents have not been annexed to the writ petition, you may be allowed to withdraw the writ petition with liberty to file afresh. Praise the Lord. Writ petition stands disposed of as withdrawn with liberty as paid for.
My lord, another prayer for listing of mutual matter tomorrow, my lord.
When did you file? When did you file?
Yes, yesterday, my lord.
It'll come up next week.
My lord, we have some problem in next week, my lord. Next week, next Monday and Tuesday, my lord, my senior will be out of station, my lord.
Then you come on Wednesday, Thursday.
But this will be last day.
You filed yesterday, you don't expect it to be listed immediately like that.
Some urgency, yeah, my lord.
See, this is a motion week. This week, next week, it'll come up. All right.
Then I may
You take up with the registry.
then for 8, my lord, I have.
Take up with the registry. I'm not giving any date.
Item number 7, in the content, taken the concept of the other side of it and the filed a I think it's the federal after the email.
17.
170.
What have you filed?
Affidavit filed.
Let us see what is the affidavit. Let it be called. You wait.
Like,
Lordship, one motion matter, Lordship. I have the filing number, Lordship. This is a very urgent one because we have challenged the impune appointment order of chief, who is junior to me. He is given the in charge of the particular forest. So Lordship, I have filed kindly tomorrow. Lordship.
Already given in charge.
Yes.
So what is the urgency now? Already given.
But my right has been violated. I'm the junior, I am the senior to him.
That is why you have a cause of action.
Yeah.
But there is no urgency as such.
Because financial power of the given to him.
Maybe. The financial power will definitely come with that. You'll come up. No. You take up with the registry, they'll list it with either this week or next week. This is a motion week, Mr. Counsel.
My humble request,
Hmm.
because all are motion day.
Hmm.
Kindly not to be allowed, because it's a motion.
That is why I'm not allowing. It's all motion day. Registry looking into the matter. Accordingly, as per the seniority, they'll list it, okay? There's no urgency as such.
Therefore, listing to similar matter, my lord. Regarding the right of pensionary benefit.
What matter?
Pensionary,
Yes, what do you want?
the matter decided after the vegetable.
What for what?
Admission.
No, you take it up with the registry. Yes.
Similar prayer.
For listing of what? For admission? Pending matters, you go with the registry, please. Take it up with them. Yes, and you? Withdrawal? Tomorrow?
Yes.
No.
Ladies, item 1 for motion.
Yesterday, someone had mentioned for withdrawal, it's not listed. What happened? So,
Maybe it's listed in some other book.
or some other court, let's say. Oh. Yes, what is the matter? Don't pass on paper just like that without submitting. Yes, what is your case?
My case has been, I was elected.
You are engaged by somebody, your clients, at least you have to perform. This is the matters like that. This is what happened last time. This is what we are supposed to do today.
I am finding.
Hmm?
2006 Lordship, 2-3 occasions I have put this on a court Lordship, last occasion Lordship, this on a to consider my case.
What happened? No, what is there in this letter? You have not read it. You have not read it. If you have read it, tell me what is written in the letter.
personal department was asked to change some instruction, but this personal department is not doing that.
Personal department. But last time K. Fukan was
Yes.
given time. You are the K. Fukan.
Personal.
Just saying, now lordship, they are seeking opinion from advocate general.
Yes, elementary education.
Opinion has been passed from the executive.
18,924, what is that?
Regarding personal debt.
What is that? Compassionate family pension.
Personal debt.
No, 18/9/2024. What is the notification about?
All other selecting appointed.
No, you are submitting that because of this notification of 2024. What is that notification?
Regarding personal debt. He has been sticking with
Hmm.
but for one time visit. It did matter was for.
So who will consider now? Personal department says that it's sent to the education department who would consider. The education department says is the personal B department. Where is the instruction? When was it sent?
Last of it.
Hmm?
First and one was 2026.
There should be some clarity. You see, time was granted to you all to get instructions. So you should be able to tell the court that this is what has happened, this is what is required to do, to be done.
Otherwise, my lord, my case was, dishonorable court order was 3/5/2023. SLC selected me, recommended my, candidate lordship.
No, when you were asked about the case, you did not say anything. I'm not asking you anything. Simply you are standing there showing your face. Should be able to tell me immediately, this is the matter.
Whether it's of eight.
What will happen in 8th of April?
I'll be.
Hmm?
Regarding.
Please write Mr. PK, Miss K. Fukan, Learned Standing Counsel. Miss K. Fukan, Miss K. Fukan, Learned Government Advocate submits that the matter has been referred to the Elementary Education Department by the Personal Department, since it is that department which deals with the matter. So Mr. P.K. Bora, Mr. P.K. Bora, Learned Standing Counsel, Elementary Education, submits that in view of the notification dated 18/4/2024, the matter has been referred. Okay, office memorandum dated 18/4/2024, 18/9/2024. What is it about? 18/9/24, which is regarding compassionate appointment as a one-time measure. comma, the matter has been referred to the learned advocate general for his opinion. To stop, he therefore prays for some time to get the up-to-date status. Considering the prayer, list the matter on
What did maybe whatever 3 times already. Right. Otherwise, next week, I'll try.
next week. Are you sure?
Immediately.
Did it come on? Huh? When? 22 for.
Plus,
Item two,
please, the last two pages, the bid was absolute. Then it's captured, and then because only point of the plan.
What is your case?
My case that.
Last court date, I was not there.
I was initially appointed on my lord 27/1/1996.
Hmm.
That is prior to the my lord, introduction of NPS scheme. And my lord, despite my appointment in the year 1996, my pensionary benefit is not deducted under the GPF own pension scheme, my lord. They are deducting my benefit, my lord, under the NPS scheme. My case is that my lord, the respondents be directed to open my GPF account, and I should be account my lord, included under the scheme. This issue has been decided by some number of occasions. And therefore, my lord, this will go directly on the last occasion. So the instruction that why the GPF account has not been opened in the case of the petition.
What is OPS?
Full pension scheme, my lord. Full pension scheme.
How do you say that you're covered by old pension scheme?
I was appointed in the year 1996.
Hmm.
At that point of time, my lord, the full pension scheme was in operation.
You were appointed as a stipendiary assistant teacher. Hmm.
Stipendiary teacher, I was given the regular scale of pay from 2012 by my lord, policy decision, because my lord, in the meantime, my lord, the government could not send me to undergo the junior basic training. It is the fault on the part of the government, my lord, and therefore, my lord,
You are given regular scale of pay as per the OM dated 27/4/2015
yes, ma'am.
with effect from 2012.
Fine.
Retrospective.
Fine.
Yes.
I think. Same matter. Similar matter.
Similar matter what?
Twelfth of May.
What is that 12th of May? Similar matter is fixed on 12th of May. So you want this matter to be on that date.
Fine.
Why not today? What is your instruction?
Of matter. Twelfth. They're gonna be taken on that day.
Miss K. Fukan, Learned Standing Counsel.
And
N. Fukan, Learned Standing Counsel. Elementary Education Department submits that similar matters have been fixed for consideration on 12th of May. And since she's yet to receive instructions, she prays that the matter will be listed on that day as well. Considering the same list again on 12th of May.
item four,
Followed this is matter regarding non-petitioners before you are not was appointed
long ago, my lord, and thereafter, his service was regularized, my lord, by order. Here, my lord, page 11, editor 1. Hereafter, my lord, subsequently, his appointment was, regularization order was terminated. On the alleged ground that, my lord, it was not regularized in accordance with law. And this in order was passed, my lord, page 16. His name is appearing, my lord, at serial number 11. This order was passed, my lord, on 8/2/2007, and total, my lord, 21 teachers were enlisted according to this order, my lord. They were irregularly regularized, therefore terminated, my lord. There, my lord, they approached before the Assam Administrative Tribunal, and Assam Administrative Tribunal, my lord, passed the order. I party, my lord, page 17, annexation 5. Here, my lord, it was provided to state them, my lord. And there is also observation, here, my lord, the bottom part of this order, the department also considered their areas payment of salary. In the meantime, my lord, some other similarly situated person employed notice of court, my lord, and passed favorable order. And I have annexed one order page 21, my lord, annexure 8. And thereafter, my lord, other pending matter is also there. Out of this 21 teachers, my lord, page 24, my lord. Recently, this honorable court, my lord, issued the notice of this matter, my lord, this case is pending. Page 24 matter is, my lord, on 2/3/2026, my lord, the order was passed, my lord, by issuing notice. And another order, my lord, page 27, this resolution is also pending.
See, after you were terminated, you have been reinstated again. When? By which order?
The order, page 19, annexure 6, my lord.
You have joined back in which date?
My lord, now, my lord, he is receiving salary.
Immediately means that was in 2011. Your termination was in 2007.
Salary he has made, my
Mr. Counsel, please listen. Your termination is 2007. Your again reinstatement is 2011.
lord.
8, 9, 10, 11, 4 years. You were not working for 4 years.
But my lord, here, my lord,
So on what basis you're claiming your area salary?
here mistake, my lord, we are out of touch.
No, any order passed by the tribunal that you should get your salary. Where?
Page 70, last paragraph.
No, let him show. I'm asking him.
Page, my lord, 17, annexure 5, my lord, last part, my lord, there are observation regarding area salary.
So this is observation only. There is no direction that gave paying the salary. Correct. So where's the decision on salary? It's not there. So on what basis you're claiming?
They were terminated, reinstated, my lord, them and them other similarly situated parts of, my lord, filing literature, my lord, and it was disposed of, my lord, to consider, my lord. I have annexed, my lord, page 21.
No.
Now, my lord, directed to
Okay, what does it mean? Regarding payment of area salary, appeal is remanded back to the administrative authority. Administrative authority would be the department. Correct? Mr. Bora, then what is the decision taken by you?
Regarding this,
Hmm.
there is the past that regarding this, it will also say, otherwise, take the matter for.
Today is the first date, but you wanted to submit many things. What is that? Hmm? Then, by filing this writ petition, the petitioner prays for a direction to the respondent authorities concerned to pay him the area salary amounting to rupees 840,101 for the period with effect from 1/2/2007 to 29/2/2012, during which he was illegally kept out of service. Next paragraph. The petitioner, along with others, were terminated from service. The white order dated 8/2/2007 for not having been appointed through regular process. The challenge was made to the same before the Administrative Tribunal, Assam, through case number 40 ATA/2010. Stop. The tribunal white order dated 18/9/2010 interfered with the order of termination and directed their reinstatement. Stop. However, as regards the area salary, that was the same was left to the wisdom of the administrative department. Stop. According to the petitioner, although he has been reinstated, but area salary has not been given to him. Hence this writ petition. Issue notice of motion returnable by 4 weeks. Mr. P.K. Bora, Learned Standing Counsel, Elementary Education, accepts notice on behalf of respondent numbers 1, 3, and 4. Ms. R.M. Barwa, SC Finance, for respondent numbers 2 and 5. Notice is complete. Extra copies be served within 2 days. On the next date, learned counsels for the respondent shall obtain instructions as to what decision has been taken by the administrative department regarding the payment of area salary of the petitioner. Stop. If any order has been passed, the same should be produced. List again on so and so.
Apply.
Item 5.
Yes.
That was held on 10 March 2006. For the promotion of from the senior scale. Selection grade level 12 to the associate professor level 30. Accordingly, when DPC was held on 13/3. But what happened in that DPC, this is only the as per the when this is screening committee is constituted. See the requires the criteria has been whether fulfilled by the candidate or not. As per the way I also and that criteria it is been specifically stated under which category what parts of the how that allocation. So this API score is minimum required for promotion to the post of an associate professor is 45. So I have to minimum score 45. So in spite of having my API score 100 47. I have been 118 pilot. I have been allotted only 40, by which I have been deprived from getting promotion from scale 12 to scale 38. So Lordship will come. This is the annexer. This is on what basis marks to be allotted. Lordship will get case annexer 31 base 48.
48.
48.
Yes, 48. Which part?
Lordship. Fine.
Yes, please read.
This is basically gas promotion by gas promotion from lower stage to higher stage of the assistant professor, librarian, selecting conducting, who is filling evaluation committee or selection committee has been necessary. Remaining criteria written in the answer B. Proceed now down. Is number 50. Well, this is the test will be actually annexer A1. This is come to the category number 3.
But this is annexure A.
Yes, but annexer.
The thing says annexure B.
Annexer B, but annexer B is not actually problem. That should be my annexer A.
The typing mistake.
I'm coming. Kindly go to my category number 3.
Hmm.
See, got it, my lord.
Yes.
It's my lord relating to, my lord, the assistant professor's selection grade to the associate professor level 38.
Hmm.
What is the, my lord, criteria, and what basis, my lord, they should be, my lord, scrutinized, and how they will be evaluated, my lord. So
You're an aspirant for promotion from assistant professor to associate professor.
Yes,
Okay.
from level 12 to level 13.
Okay.
So, my lord, it is specifically stated, that what is the requirements, my lord, the assistant professor who is 3 years of the service in the academic level of their selection grade, there will be PhD degree, there will be any one of the very swimming degree to 50 years, to complete one of the problem from amount rating, categories of the research process, then the workshop, syllabus, upgradation, workshop, etc. etc. My lord, these are various categories, my lord. There, my lord, only two, my lord, compulsory is there. One refresher and one, my lord, orientation course must be done by the one of the professor, my lord, to get the promotion from level 2 to 12 to level 38. And last one, my lord, the category number 4, my lord, the ACL. So far, even the other parties concerned, I have no grievances. But part of, my lord, the fee, how that will be decided, this is also the, my lord, the kindly come to lordship is number 50.
Page number
Is number 50.
50,
50, 5, 5.
52.
Yes. This my lord relating to associate professor promotion from my level 38. Wherever it is saying the research and the academic contribution category number 3.
Where are you reading from?
This is a table, my lord. Lordship got it.
Table 3.
Table 3, table 3, yes.
Yes.
It is for relating to me, my lord.
Hmm.
Where I have to minimum score 45. Lordship will come to the last column. This is 45 assessment points. So I have to score minimum 45 to promotion from this level 12 to level 15.
Hmm.
So now lordship will come to below the methodology for calculating the academic research score. So how this 45 will be calculated and on what basis, that is also why not highlighted here.
The 45 score in what?
It is while API score. API minimum API score I have to secure for promotion from level 12 to level 13.
What is the full form of API?
My lord.
Full form of API?
Yeah, my lord, academic, my lord, performance indication, my lord.
Hmm?
Academic performance indication.
Indication. Academic. Is it
academic, my lord, the article.
is it like APR or SER? Is it similar to SER or APAR?
ACR is a different man.
Different.
Service man of the conduct and everything that is
Hmm.
done by the management. And API is my personal mind of the activity whenever I am involved during my course for getting promotion from one level to another.
Your activity regarding academics.
Academic.
In academics.
Research work and all the activities.
Yes.
This has been kind of described
You should get 45.
that I should get minimum.
45. Yeah. How much have you given?
I from that I have been my only 40 have been
40 has been given.
In spite of my API score of 118 as part by the somewhat portal, that is mean my lord the portal is accepted in the my lord after the new education policy. This what portal is introduced in the somewhat my lord. This I don't know my exact name, but it's somewhat is there. Where my lord every college lecturers, their personal my lord they all details has to be uploaded.
Hmm.
And that to be uploaded to a AQSC that is mean all college they are individually having. And then after scrutinizing all the performance and the activity, that will uploaded and ultimately by the somewhat portal authority, they have accepted and they have entered the marks against each every category. So this is the API score on basis of which minor one promotion should be minor the scrutinized for getting a promotion from one level to another. So this is my portal, whatever is there, somewhat I have annexed minor the somewhat portal.
Where is that portal?
Yes, ma'am, I have given you.
Where?
Come to annex of 40.
Page?
Page 58. This is for cash promotion because there is a college provision on the cash promotion. Annex of 14, page 52. What's it? What it will? And 11% lordship will come. Page number 70.
Page number
70.
72.
Yes. This is the somewhat portal where my entire value qualification, my activity, everything has been uploaded and been accepted by the someone. It is not for me only, but all colleges.
What is that word you said? Somewhat?
Somewhat might not extremely.
What is that? It's an abbreviation.
Yes, and I tried to find out, but it's very, all somewhat is all only somewhat.
Where is it written somewhat here in this document? Anywhere?
Not here. This
Then
is a somewhat portal now.
how do you know what is this portal?
This is one Assam State Higher Education Portal, Assam State Higher Education Portal, and yes, application process, Assam Department of Higher Education. It will have to be approved by all the college teachers, it will be somewhat fine, somewhat fine. All activities are fine. Here also we come, page number 70.
Yes, 72.
72, category minor. Author or edited by the minor candidate.
Hmm.
So where my daughter, there are 8 numbers of the books I have edited. So from number 1 to it is published by the national publisher, then 3, 4, 5, 6, 7, and 8. This been edited by me.
So any marks given for this?
Just for this editing of this book, I have entitled for 8 marks.
8 marks.
8 marks.
But where is that 8 marks?
I don't-
Where is the score?
This is the score is given, man.
Where? Okay, immediately.
Right side of this, or on the,
This is the score given to you.
yes. For editing the all the books. So I am entitled for 64 marks total. In editing you
8 into 8, 64 marks.
64.
You are given only 40.
Again, my lord, not saying for organizing a national seminar, I am always entitled for 7 months. That is also my lord highlighted and uploaded here. So I have already my lord organized a national level seminar for which my lord I am entitled for 7 months for each. So
Anyway, this is your version, okay?
this is not my version.
Now,
This is not my version. This is what I accepted when the API score is based on this my lord.
it is your version because you have not been given that marks.
Yes.
They have
yes,
given you 40
yes,
marks. So let us try to understand what is the version of this committee. What promotion committee?
Yes.
What is this selection committee?
But selection committee, when a decision has not been communicated to me, when I immediately filed an application before the principal, he have informed me that unless and until that place before the CB, that not be communicated. So now the uncertainty is coming into that effect. When the DB will see and when my lord be everything will be communicated to me, by this time everything will be delayed and my promotion will be hanging.
CAS means what? Career Advancement Scheme.
Yes. So this is a kind of time scale, but like within 3 years of
This is a time promotion, time bound promotion,
Yes, fine.
time scale promotion.
So in spite of having all the criteria, I have not been considered. And moreover, the reason why it is not considered, I have also explained. The other reason also there, I cannot explain everything. So when to that extent only whatever I can be allowed to say, I have stated in this by case. So at least them respond on the
Where is the score given to you?
score, I have been informed that I only have that for 3 marks.
There's no document. There's no document.
No, I have asked for the document.
So the results are not yet out.
No, my thing is that I admit my lord. But they say
Then is it premature?
it is premature, but no, not the thing is that they say that unless and until the been placed before the GB, that will not be communicated to me. When the GB
So
will receive-
let the GB seat, let it be communicated to you.
But GB, when there is seat,
Then come with your grievance.
but GB, there should be some timeline, timeline. They they should see within this.
Your
because
case appears to be premature.
it is true, my lord, but GB, when.
If it is true, then I think we should not entertain it.
I have given a note. So when it is no way it is that something will come in different. Whatever I have stated, that will come in.
How do we know? It is not there.
But I know, because the college banner, the authority, they all persons are known to me, everybody. So how marks has been allotted and one of.
But that is not how cases are fought.
No, minor this.
I know everything. It is there. It will be there.
No, minor-
It is in my mind.
No,
I know.
Not mine.
How the court will accept that?
Not mine.
Huh?
I have been informed by nothing for me. informal, I have stated in my.
It's
Now,
premature,
saying,
premature.
this, but CB is this, I cannot communicate this thing. So my prayer is, at least at this stage, one direction should be given to him to seek the CB as early as possible. Because if it takes 6 months time or 7 months time.
Not possible, Mr. Counsel.
No,
I'll record your submission and close this matter. You come when the matter, when there's cause of action.
Might not be one observation at least.
No, no, no.
GB should be seek as early.
Why should we give that?
Might not
Why
be-
should we, the court determine when GB should sit, when they
No,
should
might
not sit?
be there, might not be there.
It is not our, it's not our purview.
Might not be there. Depends upon, because certain nullified cases is there. You might not GB president, GB might not be one of the selection committee members, 2 members, might not. They were totally nullified to me, so that is the reason why not I am afraid that GB will not sit in meeting. So if this something has been done and it is a long take after.
Mr. Manta,
Why not?
I think we'll close the matter.
No, my lord, I agree with Lordship, my lord, what direction should be given?
No direction.
No, my lord, but otherwise will take my indefinite.
No.
This is my one of care on.
You come again when there is a cause of action.
All that, but I come, but at least for some observation.
No. I cannot.
But the city GB and my.
Please write.
But I have a right to know, my lord. At least.
You have a right to know, you wait.
No, my lord, but see, I have to file my RT application.
I'm dismissing the writ petition now.
RT application I have filed.
You wait for the reply then.
No, my lord,
You wait for the reply.
Well, RTA, my lord, they, what? They will take the time, my lord, that is also.
Mr. P. Manta, you should know the limits. Heard Mr. P. Manta, learned counsel for the petitioner.
My lord.
By filing this writ petition, you want to withdraw, you withdraw. I'm dismissing it.
My lord, kindly see, my lord, my faith, my lord, it is.
No, you don't file cases like that, Mr. Manta.
This my lord, one observation. But I
No.
Only one, my lord.
The petitioner,
The lordship is not long that I am with them, my lord. Only that much, my lord, please.
is aggrieved with the decision of the promotional screening committee, which was held on 10/3/2026 for considering promotion of the petitioner, amongst others.
Not about, only one, my lord.
Okay, of the petitioner.
Me, my lord.
Under the Career Advancement Scheme, bracket CS. The petitioner is an assistant professor
Selection.
Level 10 is what your pay scale.
My lord.
Level 10 is your pay scale.
Well, tell my lord, this is category by the assistant professor, my lord, then from the senior
Yes.
scale, then the selection gate. Now I am selection gate, my lord, level 12. Initially,
Assistant professor, selection grade at level 11-12 and aspires to be promoted to the post of associate professor at level 13. 13 capital A. Stop. The learned counsel submits that the criteria for promotion through CS has been provided by the government of Assam in the higher education department through office memorandum dated 13/6/2025, wherein the minimum API score required for promotion is 45. Per assessment period. Stop. The petitioner contends that he has come to learn from a reliable source that he has only been given 40. What will you call this marks? 40 API score. And therefore, he will not be eligible to be promoted to associate professor level 13A. Stop. Mr. P. Mahanta, Learned Counsel, has drawn the attention of this court to the particulars, to the service particulars of the petitioner, which is uploaded in the Assam State Higher Education Portal, wherein, in respect of the publications and other research papers, the petitioner has been given the petitioner has been shown to have published what have you done? This is your publication,
Yes, madam. Eight,
published
eight books I have written, madam.
8 books, and for which he has been given 8 marks each, totaling to 64. So while such is the position, the petitioner contends that his score in the API, the score given to him in the API is only 40. Stop. Upon being asked as to whether the final score and the results of the selection has been published and intimated to the petitioner, Mr. P. Mahanta, Learned Counsel, submits that the petition has been informed that the proceedings of the selection will be placed before the governing body, and it is only then that the final result would be intimated to the petitioner. To stop. Also, any applications seeking the score of the API score of the petitioner would be available only after the GB has sat. Stop. Considering the above positions, this court is of the view that the writ petition is premature, and therefore court is not inclined to entertain this writ petition at this stage. Stop. Although Mr. P. Mahanta prays for a direction to the governing body to have an early sitting, stop. This court would not like to give such a direction in the absence of any accrued right or any specific provision by which a time frame has been fixed for holding GB. Stop. Accordingly, the writ petition stands closed. Any other observation you want?
My lord, however, have you ever known?
No, no, no.
It's taken a long time, my lord. Why appears so? To that effect, my lord.
The Mr. D. Upamanya, Learned Standing Counsel, appears for the Higher Education Department. You come when there is something, not now.
Come definitely, my lord, but it is the appearance of five parties. Possible.
Item 6.
Thank you, Your Lordship. The petitioner here is that prayer for consideration fee. Sorry. The preceding.
Praying for?
Contractual discharge.
Yes, so
As a contractual discharge, 2010. He has been serving in this school since 2010. He is final regularization and his lordship.
what do you want? Regularization? What?
To consider his contractual period while preparing the seniority. His past service as a contractual discharge.
Okay, how many years have you put in as contract teachers?
15 years.
15 years. So you say that 15 years should not go to waste. They should count as seniority after your regularization. When were you regularized?
51.
Huh?
Four.
I think some case was filed
Yes, yes, yes. Yes, yes.
yesterday. What order was passed? Notice was issued.
Because he's not qualified for the counting his seniority for the purpose of the promotion to the post of principal. Because for that, he has to continue a certain amount, length of services as per the rule. His service was
How
required to be at 20.
How many more cases do you have like this? Huh?
7 is also there, Lordship, but I have to.
Some lineup is there.
Item number 7 is the same.
7 is also same. So one more.
No, I have to withdraw. I'm withdrawing.
7 you're withdrawing. Why?
I have been instructed to withdraw.
And even the earlier case when the law is to notice, that will also be said to withdraw there also.
I will also withdraw. I have been instructed to withdraw that.
And this one?
This one I have to withdraw.
This one you'll not
No,
withdraw.
no. I have been instructed not to.
But all of them are same, isn't it?
Same.
So some you withdraw, some you don't withdraw. What is this?
That is the prayer.
Heard Mr. UP Chaliha, Learned Counsel for the petitioner, who submits that by filing this writ petition, the petitioner has sought for a direction to the respondent and authorities concerned to allow him count the period of service rendered by him on contract basis towards the seniority in the post of graduate teacher.
Graduate teacher.
Graduate teacher. Upon the petitioner having been regularized. So, Mr. SMT Chisti, Learned Standing Counsel, Higher Education, Secondary Education, at this stage submits that in order to be eligible for consideration of counting of seniority, one is required to have
Principal and this is clear.
a certain number of years of service on regular basis, which the petitioner otherwise does not have. And therefore, the petitioner cannot have any legitimate grievance. When were you regularized?
26, 25 something. He named it here by it.
It is seen that the petitioner, along with others, have been regularized as graduate teachers. As graduate teacher, by order dated 4/2/2021. with effect from the date of his joining. In view of above, issue notice of motion returnable by 4 weeks. Mr. SMT Chisti, learned standing counsel,
2, 3, and 4.
secondary education, accept notice on behalf of respondent numbers 2, 3, and 4. Ms. K. Fukan, learned government advocate, accepts notice on behalf of respondent number 1. 1 and 1. Petitioner to take steps for service of notice upon respondent number 5 by speed post within 3 days. List again after 4 weeks.
7.
I have been instructed not to place this petition.
Okay, Mr. UP Chaliha, learned counsel for the petitioner, submits that he has instructions to withdraw the instant writ petition. Stop accordingly, the writ petition stands disposed of as withdrawn. You are there, both of you? Mr. SMT Chisti, learned standing counsel, secondary education. Appears for the State Department, and Ms. K. Fukan, learned government advocate, appears for the state respondent. All right.
For orders 15 and 16.
I need some recommendation issues in 2 cases closing. Let it come after vacation because he, director posting will be out of state and we will move. So he is coming today. So let's take it after vacation.
Who is in Arunachal?
That we posting closing, he requiring me to contact.
Kaushik's matter.
If you have already appointed large number of petitioner law, only few were left, that is the reason.
Lordship, we have taken up sometime, Lordship, my senior,
Who's your senior?
Mr. Dekala.
Yeah. This is item 15. Oh. No, they are tagged together.
My page is, let's take them after vacation. This B posting has to be here. Your entire records are.
B Kaushik is for 1 and 2. How many respondents are there?
1 and 2, they are the main appointing authority. 2 is the appointing to the director. Already 1 and 3 petitioners have already been appointed.
By the way, why is it listed today? It's listed for orders. Anything has to be done? It was listed as part hard also. 19, 12, 25. For Justice Robin Fukan.
It was released. It was released.
There is no release order.
It automatically after 1 month, I think that is automatically. I think it was taken on last.
1 month or 3 months?
Sorry, appointment.
1 month. Okay. Okay. We'll have it after the vacation. Since Mr. Kaushik is not there, so what is to be done? Mr. SMT Chisti, learned counsel, submits that the matter is handled by Mr. B. Kaushik, who appears for respondent numbers 1 and 2 in the matter. And since he's out of station, we prays that the matter be listed after the ensuing due vacation. Stop. Mr. B.M. Deka, learned counsel for the petitioner in contempt case C number 764 of 2023 is also said to be engaged in a different court. In view of above, let the matter be listed on 6/5.
17.
They have received the affidavit, my lord, filed with them. Both things, that's how we have received.
It's not comply your lordship wants to produce order,
What is that?
the compliance order.
Is not here, available here?
You can find it.
You filed this morning.
Come,
Is it complied with?
that I could read and
You have to read. Compliance order is how many pages? Huh?
Order.
Give me the paper.
Not the order, communication.
If it's complied with, we should close it. If it's not complied, we'll see. What is the order to be complied with? Let us see first.
Page 32 or
Page 32.
two.
Yes. Please read.
Considering that the main purpose of petitioners of the court is directed that the cases of the petitioners be reconsidered in terms of the scenario. The procedure laid down in the aforesaid Rule 14, if they are found to be senior to any persons who have been selected, such persons have to give way to the petitioners to make their appointments. This further clarified that since the select list pertains to the entire Baksa district, the displacement has to be done from the bottom of the list to the selected candidates. The aforesaid exercise may be conducted within a period of 2 months from within.
This was a common order in writ petitions or only one writ petition? How many writ petition? In how many writ petitions?
There were 20 petitioners before the court.
No. How many cases have been filed? One case or how many cases?
3 cases.
And your case pertains to which one? 1856? Mr. Counsel, I think we'll have to see your affidavit.
Seven November, 7/25.
Hmm? 7?
7/25.
Yes, that is there.
Reference to subject, that I have the order to inform you that the order of record. So and so has duly been complied with the following action taken. Matter of the petitioners was considered in the departmental promotional PTC meeting held on 19/9/25 in compliance with the aforesaid order. After due consideration, 5 candidates falling under the zone of consideration out of the 30 petitioners were recommended for promotion to the post of headmaster of high schools under consideration.
This is not the compliance, my lord. Our direction was for the removal of 20 numbers of candidates, my lord, from the bottom. And thereafter, to consider the petitioner as 20 numbers of petitioners.
Let the affidavit be on the record. Let's see. What is your good name?
Sure.
Mr. N.R. Sharma, Learned Counsel, appearing for respondent number 2 submits that respondent number 2 has filed affidavit this morning. It is however seen that after full stop, it is however seen that the said affidavit. No, before that, he has filed affidavit this morning. And he also submits that the order of this court has been complied with. Stop. It is however seen that the said affidavit is yet to be connected to the record. And therefore, let the matter be listed. Date
8/5.
on 8/5. In the meantime, the affidavit said to be filed by respondent number 2 be connected to the case record. You take back these papers. You examine the affidavit and make your submission.
For admission, item 8.
You have received the instructions. On what basis? What is the matter?
Allowing me the enhanced pay.
Enhanced pay. Enhanced pay, on what basis? Hmm? What is the petitioner doing? He's a lecturer. University. He's an assistant professor now. And he's entitled to enhanced scale. On what basis?
That has been recommended by the page 51. What is the proof? But even then,
Senior scale. You're claiming for senior scale.
in here. The governing body in the college is also present. It's about my case now.
Dibrugarh HS Kanoi Commerce College, is it? What is your prayer here? To take steps for rectification of the roster. What do you mean?
That proposal there. I was placed in the wrong roster. There's some dispute there. I should have been in roster number 22. But given 23. There's change which cannot be done by the college.
You should be in 22. You kept your place in 23.
Mistakes have occurred in other cases also for that corrected this of my case. And the ground taken is it because my case is pending.
And the purpose of this roster is for considering your promotion later on.
Later on.
Promotion, seniority and all that. Okay. So he wants some time, we'll grant him some time.
And subject to that,
Ah.
earlier.
2 weeks, they said 2 weeks. Parties are represented by the respective councils. Mr. D. Upamanyal and its standing council, Higher Education Department, submits that he has been asked to obtain, he has been asked to pray for the 2 weeks time to file a response to the writ petition. Considering the prayer, matter stands adjourned to be listed again on so and so. 28/4. Who are 3 and 4? What is your submission?
They are supporting my case.
They are,
Hmm.
that cannot be taken. Because appointment has been done already. Of this, of the reserve post SC.
You file your affidavit.
They filed.
You filed. Okay. Mr. A.M. Upadhyay. N. Upadhyay. Learned Counsel appears for respondent number 3 and 4. And submits that affidavit in opposition has already been filed by the said respondents. When? Okay, fine, 30 April.
Item 9, In this case, your lordship. Your lordship. Pension amount has been sanctioned, your lordship. No outstanding abuses. I'd like to raise this.
All those pensionary benefits, and the final pension also released at a belated stage, my lord. The petitioner retired on the month of August 2024. And he is receiving the final pension on March 2026. And other pensionary benefit also released at a belated stage, my lord. So I am praying for interest on such delay, my lord. And those delays only because of the delay on the part of the respondent side.
Any authority on that? Not you, her. You have any judgments of the Supreme Court saying that I should be given interest? That is what I'm asking you.
Yes, ma'am.
Please write down Ms. P. Das, Learned Standing Counsel, Secondary Education Department. By producing a letter dated 7/1/2026, written to her by the Inspector of Schools, CDC Silchar, submits that the petitioner has already received final pension and DCR from the Director of Pensions, Assam. White letter dated 6/12/2025, bearing PPO number ADP/PPO/GPO/2025/K031023. Stop. It is further stated that there is no further outstanding dues to be paid to the petitioner from the said office. Next para. Miss, what is your good name? P.
Kindly allow me to submit, file one additional affidavit, my lord, so that I can, take all those documents relating the releasing of those, pensionary benefits, so that I can keep all those documents recorded.
What do you want to file?
Additional affidavit.
Incorporating what?
The amount, my lord, is said.
You are P. Goswami. Mrs. P. Goswami, learned counsel for the petitioner, on the other hand, submits that since the payment of the pensionary dues have been belatedly done, the petitioner is entitled to appropriate interest for delayed payment. And in support of our submission, she has relied upon the case of Dr. Uma Agrawal versus State of UP and another. 1999 3 SCC 238. That is all right. I'm not disposing it off. You want to file an affidavit, isn't it? She however submits that she may be allowed to file an affidavit incorporating the details of the payment that has been given to the petitioner. Considering the same, matter stands adjourned to be listed again on so and so. 255.
Did you?
Hmm.
I could tell. Maybe pleases your lordship.
Yes. You have filed already. You have to file. So we'll grant you time. How much time do you want? 4 weeks time. And Ms. P. Das, you have filed?
I am also not filing, your lordship. I have not filed it yet, your lordship. So
If pending say legal notion,
kindly,
since they are paying time for last 1 year, why?
Promotion has been stopped.
Hmm?
My promotion already has been stopped. We do get.
What is the matter? What is the matter? What is your case?
I did the master degree without taking permission of the respondent. That is the allegation.
And so
Frankly, doctors, 4 weeks time.
I've heard about your adjournment prayer. Let me ask him. You have done your,
I have already annexed it.
no, what have you done? You have passed what? Let him submit. Let him submit. Let him submit. What did you do?
MA in political science.
MA in political science. And you are a teacher. And what kind of teacher is that?
Subject is all.
Subject teacher in which school? What higher secondary school? Subject teacher. You have done your MA in political science. And for that you have not taken permission. Correct?
Already I have taken the permission leadership
And
from the.
so because of that, they are contemplating some action against you. What kind of action?
Discipline, minor discipline. Minor penalty.
Huh?
For minor penalties, lordship.
Minor penalty. Where is that? Some notice has been given to you. Show cause notice.
This is space 18 lordship.
Have you given a reply?
There. It's number 18.
84. Then after that,
The second show course. So page 85.
85.
Page 90 is the reply.
Page 90. 90 is the reply.
Second show course 85 and reply is
90. So DP is drawn now. For what? Your case is only at the stage of show cause, or charge memorandum has been issued.
only hearing.
Hmm.
Nothing has done.
Yes, who's appearing? 5, you want time? Mr. Chisti also there?
Secondary one.
You have received instructions or not?
Yeah, the complete instruction was I have seen in the November, where it was stated that a hearing was conducted. And the petitioner was appeared and it was found that the question arise regarding the BA degree acquired by the petitioner from Royal College. And also came to the light that the petitioner has two married wives, which he admitted in had from the government rule. A CIG inquiry is presently underway regarding the degree obtained from Techno Global University, Madhya Pradesh. So this is the instruction of November. So I am asking for the update. What happened to the inquiry? So several cases are pending against the petitioner. So allegations are there.
Okay, whatever it may be, you file a response.
Immediately after taking.
3 weeks time. We'll grant him some more time.
Some more time.
It's counted.
Hmm. He said 1 year has gone.
It's clear that I have taken the principal.
Okay. 1 year has not, you said 1 year is gone. 1 year is not completed. It's only 10 months. Filing date was 6 June. Anyway, we're not on that. There has to be a response. Let us see
17 next year.
next year. So 3 weeks time.
After taking.
I have one point.
Yes, yes.
Legal. For the legality of the degree I have gotten from Britopol, that was question in another earlier question. This another will go and my degree was ready. So subsequently, either they have to file appeal against this order. In absence of filing any appeal, how can now they say, "Oh, you are not my degree."
This is your second writ petition.
Yeah, this is.
Are you also yet filed?
Senior.
Hmm.
Because of the pending degree, I was not promoted to the principal.
Hmm.
Therefore, my lord, I have challenged this degree. This degree is time partner, almost after 8 years.
Hmm.
Only after filing my first application, that they come to the action, they came to the action.
No, earlier writ petition was filed by you on what? Challenging what? What did you challenge?
Page 72 is the relevant portion. That my senior, the existing principal was being retired on 24. And I being my lord,
No, there's nothing saying that your degree is valid, unvalid, not valid, nothing like that.
page 80.
You're saying that it's premature, court has said it's premature. That's why.
Page 80, paragraph 10.
Oh, page 8.
79.
How many writ petitions have you filed?
Page 79. This is, I am referring this.
No, just ask me, just tell me, how many writ petitions have you filed?
This is third.
Third. That's why I thought there was only two. There is 3 writ petitions.
Page 79, my degree was held to be valid.
And these are all for inserts, these are temporary loss arrangement.
Otherwise, in the gradation list, my name appeared. I am otherwise, my lord, eligible for a promotion, my. But now because in order to deprive me, my lord, after almost 8 years, the proceeding has been initiated.
Anyway, we'll give them some time.
The date will be fixed.
Mr. SMT Chishti, Learned Counsel, appearing for the Secondary Education Department, as well as Mr. S. Huck, Learned Counsel, for appearing for respondent number 5, and also Ms. K. Fukan, Learned. Are you filing anything?
There one aspect.
K. Fukan, Learned Government Advocate. What did I say last? K. Fukan, you cancel that. Mr. So and so, number 5. Submit that they have not yet received instructions in the matter, and therefore they pray for 3 weeks' time to file the counter affidavit. Ms. K. Fukan, Learned Government Advocate, appearing for respondent number 1, submits that respondent number 1 will not be filing affidavit. Respondent number 3 will submit that respondent number 3 will not be filing affidavit in the matter. Next para, considering the fact that the petitioner is due to retire in the year 2027, the respondents concerned should file their response by the next date. List again also and so.
I have.
Okay.
I don't know, my lord, in absence of filing any response.
They're not required, not now.
Okay.
Let them file.
Item 11.
It's for each of the area of the petition. This is my biggest communication. The department is not also trying to get the petition raised, the vacancy.
Since they have accepted the prayer, let them comply, do the needful within a period of 2 months. Till then, my lord, this petition may be kept pending. On the next day, your lordship may dispose of this.
So just a minute. Four. Notice has been served to everyone? 6, 7, 8? Who are they?
This has been started. They are not, 7 and 8 are the principles where, the petitioner was, 7 is the initially appointed principal, principal of the college where he was initially appointed, and 8 where he is presently working. And 6 is the state level police recruitment board who has initiated the recruitment process. Service is completely, so we will find out which number is there.
Yes, so
With the company for payment, the payment will be paid.
Mr. Dew Permania, Learned Counsel for the Higher Education Department, by producing a letter dated 10/3/2026, 3, to the Government of Assam, Higher Education Department, to the Director of the same department, submits that the Director has been directed to take necessary steps for release of salary of the petitioner as admissible under the rules. Stop. He therefore submits that the matter may be taken up after the ensuing Bihu vacation so that he can come up with an up-to-date status about the payment of salary to the petitioner. In view of above, list again on sons. 13.5. Letter dated 10/3/2026, produced by Mr. D. Upamanya, non-standing counsel, higher education, is kept on record and marked as X. Right.
There was an advertisement lawsuit of, following an advertisement lawsuit, the petitioner was selected as and appointed as a science graduate etc. On 1/3/1994. Thereafter, lawsuit he received salary for 1 month, then lawsuit his salary got abruptly dropped. In the point of time, some excess appointments were made. I was also placed under the screening, which was done by S. Manohara. But the committee did not find any infirmity in my appointment law. And accordingly, I was regularized from the date of my initial appointment. So you may kindly see the regularization order at page 28.
Just a minute, okay? Ms. Fukan, you ready? N. Fukan, are you ready for hearing? No, you submit it when your turn comes. If you're ready, you wait.
You may kindly see the.
Just a minute. Yes.
The director in his affidavit has admitted everything also. Admitted question. Also, may I go for the first, right? The first question, may kindly see the annexure 1. That is the
Next.
advertisement also. Advertisement for also, I have applied for the science graduate teacher. That is 5474 number of science student for middle school. The qualification required is BSc with maths. The petitioner possesses that same qualification. Then Lordship may kindly see my past appointment letter at page 24. Annexure 3. Annexure 2 also. As per approval of the advisory board and subject to research without any notice and assigning any reason, Sri Lakshman Basak is hereby appointed against the newly created post for graduate science teacher for middle school and allotted post of Binapani United and School in the scale of pay of influence. Plus other allowance at Shiva under government. This is my initial appointment. Then my annexure 3 is my joining letter also. Page 25.
Yes.
Then give the certificate by the headmaster of the. And I have not drawn salary from 1/3/19. From 1st of May 1994. At the point of time, some excess appointments were made. So I was also subjected to screening. And that screening was done by S. Manohara Lordship. And Lordship, in my case, Lordship, no infirmity was found. Since I was appointed against the sanction post, the post creation number I have. I am also annexure 5. This is the regularization order. Annexure 5, page 28. in pursuance of the government circular number so and so, and in pursuance of WP message so and so, of Commissioner and Secretary Education Department, Government of Assam, Sri Lakshman Chandra Basang, signs in the picture of Binapani United and his school, which was acquired into by one-man committee headed by S. Manoharan, IS, and subsequently by the task force district level screening committee and department in house committee is hereby regularized his service with effect from 1/3/1994 in Binapani United and his school against the post originally created by government creation number 16/11/1990. So in my case, Lordship, we have the government creation number and the post is allowed. So
What is the date of the order?
this order is 21/3/2001.
What about the top of the page?
Top is written as 28/2001.
So why two different dates?
So this memo number when this process of maybe typing.
So which date should we look, should be considered as the actual date? Huh?
1/3/2001 order.
Then,
Then here also this petitioner also it was transferred to Manipur Basic School, intermediate school. That was a wrong done by the Lordship department also. Because the science to the teacher, they received graduate scale of pay from the very date of initial appointment.
what is page 29 in extra 6?
It's a transfer order. Is hereby adjusted and posted is with immediate against existing vacancy post of Manipur Senior Basic School. Against Kalikota Das retired expired and this post was vacant against the original post creation number so due to adjustment of original incumbent against the post incumbent. This post retained by so and so. The expenditure will be debatable to the head of account.
What is the scale you're supposed to get?
Science data teacher also they received graduate scale from the very date of initial account.
What is the scale? That is I'm asking. They are supposed to get from this date, that date. Is not the question. The question. What is the amount?
Yes, ma'am. Lots of at page 33, lots of ROP I have given of 2010. 5 to graduate teacher science. Lots of page 33. Page 1 2. Five two zero zero two and 2800. Yes.
What is this? Report of Assam Pay Commission, 2008. Revision of pay rules, ROP rules 2010. You were appointed in 2001. That time the scale given to you was how much? No, 2001, 1994. 1375. 3375. That was the scale. And this ROP 2010 applies from which date?
From 17th of March. Was notified in 2017, giving retrospective from 2010.
From where are you seeing that? You have not annexed the relevant portion also. You have just given the front cover and the last somewhere then page. What is page 34?
Page 34 also, this is the 2017 revised also.
Anyway, I'll take a break and come. Yes.
I was referring to annexure C, A6, base 29. I was transferred from Manipur to
You are referring to a page?
base 29.
Yes.
Thereafter, also there was a retention order also. In this retention order, annexure 7, page 30. I was wrongly shown as a assistant teacher instead of science graduate teacher. At page 31 at serial number 22.
You are shown as what?
Shown as 80, also, that is assistant teacher. It should have been a science graduate teacher.
What is your name?
My name is Lakshman Basak.
Hmm. Assistant teacher. In middle school. What is this order otherwise?
This is a retention order of 67 number of posts of assistant teacher in middle schools, retained with effect from 1/3/2003 to 29/2004. These posts were originally created by government letter, so retained by. Then let's say my service was confirmed by annexure 10, let's say page 36. This is the type copy. Annexure 10, also, my service was confirmed
As what?
as assistant teacher also.
So,
So this wrong has been continued. Now,
wrong
this
continuing,
has
but
been-
what did you do? What did you do?
I agitated, also, this wrong has been corrected.
How?
only in
How did you
2017.
agitate?
17, also, it was
First,
corrected.
you were shown in 2003. Again in 2010 also. What did you do?
Then let's say annexure 11, let's say I was again allowed to work in Aloguri MB school, and I complied each and every transfer order of it. Now, let's say the correction order is 2017. also. Now they realize the mistake, let's say, and they have placed the order. Annexure page 39. Annexure. Also, in pursuance to the government circular dated so and government circular dated so and D Assam's letter number so, dated 6/3/2003, and this office order memo number so, dated 23/2003, Sri Lakshman Basak, BSc, regularized his service at Manikpur Senior BC School as assistant teacher. Now, Sri Lakshman Basak, BSc, is working at Aloguri MB School under the BO Manikpur. By his office order memo number so, dated 10/11/2016, and continuing his duties as science teacher at Aloguri MB School. Sri Lakshman Basak, BSc, AT of Manipur Senior Basic School, and utilizes his duties at Aloguri MB School as science teacher. He is hereby allowed to hold the post of science graduate teacher by Sri Tridip Chaudhary, science graduate teacher, transfer. Consequently, Sri Lakshman Basak, BSc, is allowed to draw the grade pay of science graduate teacher, that is rupees 3300 per month in the pay band 2 plus other allowances as admissible under the rules with effect from 1/3/2017, instead of grade pay of 2 at the rate of 2050 in the pay band. And this post were originally created by government letter dated 1992 and retained permanently by dated 6/8/2003. The posts were retained permanently, and lots of this order, after a lot of hesitation, lots of hesitating his grievances in 2017, they have realized their mistake and have passed the order. So from 2017 onwards, lots of I have been getting the science graduate, the scale pay attached to the post of science graduate teacher. Then thereafter also I have also filed my ELS. And my service book also I have been given financial application also administrative benefit.
What about your past service?
Yes, from the past service, let's say I was initially appointed as a science graduate teacher. My very initial appointment.
No, what I meant to say was that as per this order, you have been now given the
From 2000.
scale of
I have.
graduate science teacher 2017 onwards. What about the previous years?
I received this scale of pay only for 1 month when I was initially appointed. From 1/3/1994 to 34, only one.
You have slept over your rights. In short,
Last year I
that's all.
that 17.
How you agitated? By what? Doing what? Your writ petition is of the year 2025. Any other writ petition filed earlier? No. Then how do you turn back the time like that?
Because this is fact also, sir, I am continually working as a science village teacher from my very date of initial appointment. And also if one.
Nobody is questioning that. You are doing that. You are also keeping quiet. You are always shown as assistant teacher everywhere. 2017, they said, okay, from now on, you'll become graduate teacher. Again, you keep quiet. You never ask, what about the earlier days from my initial appointment?
I did not visit them. Because my service
From
was regular,
which-
it affect from retrospective dates, from the date of my initial appointment. Council may kindly see my regularization order.
No, you have not. Where is your regularization order?
Page
28.
28.
From 1394. Correct.
Service. And I have been continuing the post working there. So I should get the area salary also for this particular month.
Which month?
Proceed from 1/5/1994 to 19/3/2003.
19.3. What is that 19.3? What is the significance of 19.3?
From 2003 also, I have been given pay in the intermediate scale of pay. So from 23/2003 to 83/2007, I should be given the scale of pay attached to the post of science user. 1/5/1994 to 1/19/3/2003, I did not receive any salary. And from 23/2003 to 83/2017, for this particular period also, I received salary in the intermediate scale of pay, which I should have been paid the pay scale also attached to the post of science user. And from 2017 also, they have given me the tax industry. And in the academic also, they have admitted this facts. And unlike other teachers, let's say where they have found excess teachers, those teachers also they were either terminated or also their services were regularized from a prospective date. But my regularization order is from a retrospective date, from the date of my initial appointment. So I should not be deprived of my area salary also, the period which I have worked.
Have you filed any representation?
Yes, but
Where is that?
page 66.
What is the response? When did you file this?
36/2025.
Hmm?
Petition was filed in the month of August.
Madam, I'm not asking you.
Also, I have also.
No, please come to page 66.
Page 66.
What is the date?
36/2025.
25. So what were you doing all these days? All these years, you have not said anything. Suddenly you have come like that. Why?
Because they have rectified their mistake only in 2017. After a lot of.
So you should have come on 2017 itself. Give me my area salary. Instead, you waited for another 8 years.
One similar order also I have annexed, which is 7/67.
In next year?
Annex of 17/67.
So after looking at this judgment, you thought you'd get the same relief when you have come. Do you know this was filed in 2008?
I mean, the affidavit filed by the director. They've admitted also. Paragraph. Page 71, running page of the affidavit. Paragraph 4 of the, that's about a report of a district of the petitioner was appointed as science teacher at Pinafan in the case of the post of
Paragraph number?
paragraph number page 71.
Hmm. There's a slight correction. It's page 70 now.
And they're also giving the reason of the paragraph 5. The answer is that as reported by DO Bonga, the salary of the petitioner had been stopped with effect from 1.94 to 19 due to LS appointment in excess. And subsequently his service was adjusted as patient teacher and posted as money senior president.
These are the facts only. What is the question of admission?
They have not said that I was regularized. My service was regularized from the date of my initiative.
No, see,
Once my service is regularized, the date of my initial appointment. Once we get the salary for the right. In paragraph 7 also, they have admitted this fact.
affidavit is neither here nor there. Is it stated anywhere about your regularization in the affidavit? Only your initial appointment is shown as graduate teacher, correct? Then in your writ petition, you said that you have been regularized.
Regularized from the very date of my initiative.
That is the page.
Page 28. The express appointments were entered by the one-man committee. And they did not find any infirmity in my case because there was a allotment number, post-creation number.
Annexure 5.
Acquitted for getting selection from. In other cases also, they were either some teachers were either terminated or they were services were regularized from a prospective date. But in my case, it was from my very date of initial.
Paragraph 6. Paragraph 6, 5 and 6, there is no comments. No comments.
Paragraph proceed.
You say in paragraph number 6 that you have been regularized with effect from 1/3/94, initial appointment. In reply, they say no comments. That's all.
After they go this time, and for area apartment.
No, he has been regularized. He has regularized with effect from 1/3/94. You have nothing to say on that. You accept it. Uncontroverted statements means admission.
He was appointed after this, his appointment. Kindly see paragraph 5. That with regard to section paragraph 4 of the restriction, the answering respondent is likely to be stated as reported by the CEO Gauhati Assembly of the petitioner has been stopped with regard to so due to Ali's appointment is excessive.
So it is not that it was due to excess appointment. It says due to allege. Allege means it is not final. Somebody alleges you have done something. People are accusing you of something. There is no finality. Allegation is an allegation. Then you cancel the appointment. You have not done that. You have gone ahead to give him the regular scale later on in 2017.
And for the area part, is only for people. Immigration period is not important.
Where is it in your counter affidavit? It is a reported judgment. You think court doesn't know? Where is it written in your affidavit that there is delay? You simply file affidavit like that. He'll recite some facts, you'll recite the facts and file affidavit. Neither here nor there. No denial, no admission, nothing like that. Whatever he says, yes. And whenever he says that I have been regularized with effect from my initial date, you say no comments. So, I mean, it's, I don't know what to say also. An affidavit is filed by the director. Tomorrow, appeal will be filed by the secretary. Is the director of the government? Huh? Yes. Director of whatever department may be. Does he represent the government?
He's the director of litigant. He's the main responsible.
You also don't play the same, being on the same boat. I'm talking about the government.
Government.
Who represents the government? Director?
Government is represented by the secretary department.
Then that is what I'm saying. Affidavit has come from the directorate. When you say do something to the director, he'll say that no, I have no authority. I have to seek approval from the government. So if he is not the authority, why did he file affidavit?
My guess was the director is the appointing authority.
So what do you say about that 3 years?
This is allowed. This honorable court entertaining such area salary cases are being entertained by the honorable. My lord, second period from 23,003 to 83,017. Has received the salary in the intermediate scale of it. I am praying for giving me the pay at last to the court of science visitors, minus the salary already drawn, the intermediate scale. Because I was all along a science visitor. There is no dispute of that.
Three years will be from which date? From receiving last salary, what do you mean?
Get the permission. You have to buy this section with it, not the 70. Of the thing.
PS from which date? This Tarsem Singh. Please get this judgment. 1995, 5 SCC, 6 to 8. And 2008, volume 8, SCC, 648. And 2010, 12 SCC, 538.
May I make one sub?
Yes.
Also with regard to my second prayer home, I have, this judgment will not be applicable because also I have claimed the difference also. Because I have been given the salary in the intermediate scale, I am asking in the scale of pay attached to the post of thank in the graduate scale of. I was given salary from 23,2003 to 3,2017 in the intermediate scale. So minus the drawn salary also I am asking for the thank
You have been receiving that assistant teacher's scale when?
the intermediate scale from 23,2003 to 83,2007.
Start receiving that scale of assistant teacher?
From 23 to
2003.
I got the Thanksgiving scale also. Then also the absolute stop also from 1594 to 1903 to the.
So after 2003, when did you start agitating again that I should get the graduate scale? Hmm?
From this in 2017 they rectified.
They rectified on their own.
Yes. No, after my deliberation also there.
They rectified on their own. What, there is no indication about deliberation or your representation or whatever. Nothing like that.
I could obtain as an assistant.
And you gladly accepted that. Okay, from now on, I'm getting from 2017, I'm happy. That's it. But then in 2025, now you come up with a case saying that I should be given from the day one.
I worked for that period and my service was regularized with that perspective.
You have, there's some delay, you see. A lot of delay.
Yeah, yes, something. But with regard to the second part of second period also, I already received salary. Only the difference I'm asking. Minus the drawn check.
So that difference also can be calculated for 3 years. Is it possible?
Cases, certain areas where
Ms. Fukan, do you know the concept of 3S? What is it? 3S from where? Hmm? And what is that date?
He's receiving why he's 48 years, yeah, that's all. After so many years.
No, he's receiving salary till date. He's receiving at the lower scale till 2017. From 2017, it was rectified. You're getting the graduate scale.
From 2007, single.
What he is claiming is that from the initial date of appointment for 1-2 months, he was getting graduate scale. Thereafter, that was discontinued. That was only rectified in the year 2017. From the initial appointment to 2017, the difference of the graduate scale and the scale of given to assistant teacher, that difference he should be paid. That's what he's saying. You are bringing the concept of 3 years. How do we apply this 3 years? From which date and on how do we apply? Because nowhere in your read petition, in your counter affidavit, you have made a whisper that he has come belatedly, we cannot give him. You said that you admitted, okay, there was some excess appointment allegation was there, so that's why it was, no, he was not paid salary for some time. Whatever he has said, you have said yes.
That he claimed previously from 2003.
Yes.
So,
Hmm.
for areas,
Hmm. Yes, from when?
he's, civil and as a whole.
No, what was his initial appointment? You agree that he was appointed as graduate teacher. If you do not give him that salary, then
That apartment. Already.
no, if it was excess, what steps have you taken? Have you discontinued your service? Adjusted him as what? Assistant teacher. Let us see.
Fighting. Wasn't verified, no contribution. Pending in the department. As what is significant.
My regularization order is very clear. In the regularization order itself, the
Hmm?
Other kinds of care also. Release the pending areas relief of the petitioner with effect on 2023 to 2003 to 2017 for the areas. He's not paying for the grade pay or any other allowances.
read the entire paragraph. Minus the salary only.
on the strength of regularization.
The regularized total also, it has been clearly stated that my current and areas will be released after receipt of additional budget allotment of fund from government. And after verification of due and wrong.
Please read that annexure 5.
In pursuance of the government circular number so and so dated 10/8/2000, and in pursuance of WT message number so and so dated 24/1/2001 of Commissioner and Secretary Education Department, Government of Assam, Sri Lakshman Chandra Basak, Science Graduate Teacher of Pinapani United ME School, which was inquired into by one-man committee headed by Sri S. Manoharan IAS, and subsequently by the task force district level screening committee and department in-house committee, is hereby regularized his service with effect from 1/3/1994 in the Pinapani United ME School against the post originally created by government creation number dated 16/11/1991 and government allotted number dated 25/1/1994. The expenditure will be made from the grade of account 202 general state and schemes salaries. The current and area salary will be released after receipt of additional budget allotment of funds from government and after verification of due and wrong statement received and same after being authenticated.
What is this 1/3/1994? No, just a minute. You read the first two lines, this as a reference of the authority, madam.
Government
Now, what is this 1/3/1994? With effect from 1/3/1994, why is that? Where is your initial appointment?
case 22.
Show me the date, 1/3/1994. Where's the date?
Since I have joined on motive 1/3/1994. My appointment was 28/2/1994, phase 24. I joined on 1/3. So it is the date is 1/3/1994.
Oh, date of joining, that's why. So after 2001, what happened?
After 2001, I was transferred to various schools
As what?
as assistant teacher. Then after receiving salary from 1/3/94 to 34/99.
See, there is nothing mentioned about your salary.
Then that inquiry was there, regarding fixed appointment.
There is no mention about your salary in annexure 5. How much scale you are entitled to?
Next five. It is to be constructed since I have been appointed as a science graduate teacher. I can get the scale of science graduate teachers.
Then after this regularization, which was followed by your transfer elsewhere, then what scale were you given?
Excel 6.
What scale were you given?
The intermediate.
What scale is this? 3130 to 6,600. Oh. Can you have a printout? Get a printout. You get a printout or you keep in the file. We'll have it some other day.
And also people also say my service book. This clearly there. Everything is in.
No, nothing is clear. That's why we are in all this confusion. What is annexure 6? Your transfer. In same capacity as graduate teacher, isn't it?
the retention order was wrong, Annex 7. When I was, this retention order was passed, I was shown as assistant teacher instead of science teacher. Page 31, detail number 20.
Your nomenclature is assistant teacher, but what about your pay? It is not shown anywhere. You may have been wrongly mentioned as assistant teacher, but did you get the scale of assistant teacher? So where is the evidence? Wrongly, they have said you are an assistant teacher. But you might very well be getting your graduate scale. Do they admit in the writ petition, in the counter affidavit, that you have been getting only assistant teacher scale? They don't say anything.
There is no denial of whatever I have said was considered the correct.
Anyway, by virtue of this order at page 39, correct? Something is mentioned here, please read.
In pursuance of the government circular number 10/8/2000 and government letter dated 25/11/2002 and the CE Assam by letter number 4/5/2000 dated 6/3/2003 and this office order memo number 23/2003, Sri Lakshman Basak, BSc, regularized his service at Manikpur Senior Business School as assistant teacher. Now Sri Lakshman Basak, BSc, is working at Alauguri MB School under the BO Manikpur by this office order memo number dated 10/11/2016 and continuing his duties as science teacher at Alauguri MB School. Sri Lakshman Basak, BSc, HP of Manipur Basic School, and utilize his duties as Alauguri MB School as science teacher is hereby allowed to hold the post of science graduate teacher by Sri Dilip Chaudhary, science graduate teacher, transferred. Consequently, Sri Lakshman Basak, BSc, is allowed to draw the grade pay of science graduate teacher, that is 3300 per month in the payment to plus other allowances as admissible under the rules with effect from 1/3/2017 instead of grade pay at the rate of 2,500 in the payment. And this post were originally created by government letter dated 16/11/1991. So it goes back to my earlier initial appointment and retained permanently by government letter dated 2003. Post was retained in 2003, permanently created. So there is no dispute at all of this post was there from the very date of initial appointment. Government creation number is there, sanction post, and I was appointed as the sanction post of science graduate teacher. So I with them came out with the science graduate teacher. Here is the certificate of the Annex 14, page 14.
See, you after your posting to Manikpur Senior Basic School, again you are transferred to Alauguri. In 2016.
Okay, I have complied with each and every order of the government. And here is a certificate from the research headmaster.
So from this order itself, you see at page 39, the order by which you have been allowed to get the grade pay of science graduate teacher. It appears that they accept that you are getting the grade of assistant teacher. But from now on, we are giving you science graduate teacher scale. That's what they're saying. They don't admit that you were wrongly denied. They don't say anything like that.
My initial appointment, my regulation, is ordered the effect that I was appointed as the science graduate. Annex 14, page 14, my country is being. This is a certificate given by the in-charge headmaster of Alauguri and Bishop. Just to confirm that the Lakshman Basak worked as a science graduate teacher at Alauguri MD School from November 2016 till he excelled in teaching mathematics and science.
One thing, well, Ms. Fukan, you get some more instructions. I'm not satisfied. Yes. Whether he has been wrongly denied or not, that part. Because your affidavit only saying yes, he says some facts, you also say yes. So you're just repeating what they're saying. So
There is no denial.
he's right. It is the case of the petitioner that although he has been appointed as a as a graduate science teacher of middle school, White order dated 28 to 1994. And subsequently regularized as such, White order dated 1/3/2001. No, White order dated 28 to 2001. Issued on 1/3/2001. Bracket annexure 5. Comma, he has been deprived of the graduate scale of pay till the same was restored to him. White order dated 20. I don't know why there's an overwriting every time. White order dated 22 to 2017. Bracket annexure 12. The affidavit filed by the director of which director? Elementary education. Does not disclose as to whether the petitioner had been wrongly deprived of his graduate scale of pay by giving him the pay scale entitled to assistant teacher. Correct? Next para, the appointment order of the petitioner as well as the order by which he has been given the graduate pay of he has been given the grade pay of science graduate teacher refers to government circular number capital A bracket I capital E 425 slash 95 slash PT dash Roman 2 slash 140 dated 10/8/2000. And also the post creation order of the government under memo number EPG dash 567 slash 90 slash 109 dated 16/11/1991. What did I say before that?
The appointment order of the petitioner as well as the order by.
Before that, ah,
The appointment order of the petitioner as well as the.
no, that is new para, that much okay. But before that, what did I say?
The affidavit filed by the director of elementary education does not disclose whether the petitioner had been wrongly deprived of his graduate scale of pay by giving him the pay scale and to assistant teacher.
Okay, then next para.
Next, the appointment of the petitioner.
Okay, that's okay. Then now next para again. Considering the above the respondents will have to clarify as to whether the post creation has been done for graduate science teacher or otherwise. And further, whether the petitioner had been erroneously given only the scale of pay of assistant teacher instead of the scale given to a graduate science teacher. By filing an additional affidavit. Stop, the additional affidavit should be filed by the, who will file? Director. Again, Director of Elementary Education, Government of Assam, bracket respondent number 2. Within a period of three weeks from today. List this matter again on 28/4/2026.
Right.
Who's for the other side?
Last chance is given by the last order worship.
Okay,
That's not there. Last chance, last occasion, last.
okay, although last chance was given for filing affidavit in opposition, but Mr. U. Sharma, learned counsel for the secondary education, submits that the affidavit has been sent for vetting and praised for how much time? 10 days time to file the affidavit in opposition, considering the same. 10 days time is granted as paid for. List again on so and so. This is item 14. 14. What about item 13? Anybody? 13? Hmm? Is set aside.
Continue her service for.
Okay. Affidavit has been filed or not? Not yet filed. Show me the file. Item 30. Hmm? Yes.
Final affidavit. Already sent it for vetting, your lordship, some correction is needed.
When did you send for vetting?
Already sent, your lordship.
When? Are you sure?
Yes.
This case or some other case? Ms. P. Das, Learned Standing Counsel, Secondary Education Department, submits that the affidavit of possession has been sent for vetting and therefore prays for 10 days time to file the same. Praise the Lord. List again nonsense. Hmm.
For admission, item 1, WPC 27 of 2025 pertaining to item.
Yes.
Last provision I
Hmm.
was submitting that under section 44 double A of the Income Tax Act, books of accounts are required to be maintained only here for the purpose of I'll just will kindly just once more refer to 44 double A.
Double A.
44 double A.
Hmm.
Kindly refer to subsection 2.
Hmm.
It refers to every person carrying on business or profession not being profession shall, if his income or profession exceeds so and so, or turnover exceeds so and so in the previous year. So Roman 1 and 2 sets out the monetary, my lord, the limit.
Hmm.
Then 3 and 4 also. Three and 4 are relevant to the deeming provisions, where the profit is computed under the deeming provisions of 44 AE, 44 double B, triple B, or AD. So my case is not 3 or 4. My case will fall in 1 or 2. But it says that the keep and maintain such of books of accounts and other documents as may enable the assessing officer to compute his total income in accordance with the provision of this Act.
Hmm.
My lord, my turnover.
Hmm. You say that 1 and 2 applies to you.
Yes, my lord.
1 or 2 may apply to you.
One apply, but well, it is subject to the condition that keep and maintain such or books of accounts or other document as may enable the assessing officer to compute his total income in accordance with the provisions of this Act. So the only purpose of maintenance of books of accounts is to compute the total income under the provisions of this Act. Now, my lord, kindly come to section 10. Section 10, my lord.
So lengthy section 10. Just 10. Yes, section 10.
Section 10, my lord, kindly see chapter 3.
Yes.
Incomes which do not form part of total income. Then, my lord, the heading of section 10 says incomes not included in total income.
Mm.
Then, my lord, section 10 starts with in computing the total income of a previous year of any person. Any income falling within any of the following clauses shall not be included.
Mm.
So for total income, my lord,
Hmm.
computation, the exempt under section 10 is not to be included. And 44 AA says that books of accounts are required to be maintained only if, my lord, I have to compute the total income. It should enable the assessing officer to compute the total income. Total income means income which is liable to tax. Once it is not liable to tax, it goes out of the purview of the total income, my lord. I will demonstrate that from the return also, which I have enclosed with my petition, my lord. But before that, my lord, kindly refer to one judgment. My lord, the third compilation which I submitted on the last occasion, my lord.
Which case is that?
Third compilation, my lord, it starts with rule 6F on the.
Yes.
The serial number 1 is rule 6F.
Yes.
Yes. My lord, kindly refer to page 6 onwards. It is a tribunal judgment. Page 6.
Mm.
Then, my lord, kindly go to page 14, my lord.
Mm. 14.
Page 14, my lord.
Yes.
One second. No, my lord, kindly refer to page 6. Sorry. Page 6, then, my lord, page 6, kindly refer to page 8. Page 8.
Yes. Which para?
Paragraph 6, my lord.
Mm.
The last, my lord, 2 sentences I am reading out.
Mm.
Therefore, income exempt from taxation under section 10 shall have to be excluded before computing the total income. To that extent, we are in agreement with the contention of Mr. Gura, landed counsel for the SSC.
Mm.
So income exempt from section 10 has to be excluded for computing the total income. So my submission, my lord, is that I was not required to maintain books of accounts. Nevertheless, my lord, section 44A, even if did not mandate me to maintain books of accounts, I had maintained the books of accounts, my lord. But I have submitted, my lord, that on page my lord, 80, my lord, 80 of the petition.
Mm.
Page 80.
Yes. 80.
In a case where regular books of accounts of the business or profession are not maintained, furnish the following information as on 31st day of March 2022.
It's
Respect
just-
to business of profession.
So
Amount
just-
of total sundry debtors 1240.
Just a minute. Just a minute. You said 80
Page 80.
of the writ petition.
Writ petition.
Why is this different then? Which part you're reading? 80?
Column 6.
Or in case where a regular book? That one? Okay.
Of business or profession are not maintained,
Mhm.
then furnish the following particulars.
Mhm.
Amount of total debtors, 1245,950. Amount of sundry creditors, 984, 550. Stock in trade, 95,85,625. Then cash balance, 189,562. But this precise, my lord, the information or the details, my lord, it could not have been prepared without maintenance of the books of account. And the reason, my lord, it was put here is that, my lord, kindly refer to the, my lord, the computation part, page 137, my lord. Computation of total income.
Hmm.
Computation of total income.
Yes.
My lord, kindly see. Column 3, profit and gains from business or profession. Profit and gains from business and profession other than speculative business and specified business, A38 of Schedule BP. Now, my lord, kindly refer to Schedule BP.
Where do we get that?
Schedule BP is, my lord, page 79.
Yes, Schedule BP.
Sorry, it is page 92. Computation of income from business or profit. Kindly on page 94, kindly have 38. Net profit or loss from business or profession other than speculative business and speculative business, A38. Now, my lord, this A38 will come to this page 137 automatically, my lord. In the IT software, it will be automatically captured. My lord, learned friend said that I have put nil figure here in this profit and loss account. The reason is that if I had, my lord, supplied figure over there, it should have come in the computation of total income. My income is exempt, so it is reported elsewhere, my lord. That is in the, but there is a separate, my lord, schedule for reporting of the exempt income, which is on page 127. 127. Kindly see, my lord. Details of exempt income. Again, it is very categorically stated income not to be included in total income or not chargeable to tax. So it either it can be included in the total income or it can be included here. So if I supply my figure of profit and loss account in the those schedule for profit and loss account, it automatically goes to the computation of total income. And automatically, the tax will be computed by the IT software. These are not physical returns. In any case, I cannot put wrong figure. And exempt income, I have reported, the only error on my part is that instead of 28,95,625, the figure reported is 289,56,255. That is the error, my learned friend submission is that just because I have put a wrong figure in the IT return, so I should not be now eligible for the benefit under section 1026, my lord. So I just want to demonstrate, my lord, what are the powers of the commissioner under section 264, which enables him to correct even the error committed by me in filing of the return, my lord. There are two judgments, but prior to that, my lord, kindly refer to section 264, my lord.
Yes.
In the case of any order other than an order to which section 263 applies, passed by an authority subordinate to him, the principal chief commissioner or chief commissioner or principal commissioner or commissioner may either of his own motion or on an application by the SSC for revision call for the report of any proceeding under this act in which any such order has been passed, and may make such inquiry or cause such inquiry to be made, and subject to provision of this act may pass such orders thereon, not being an interest prejudicial to the SSC as it takes fit. So once, my lord, an application is made under section 264, then, my lord, an order prejudicial to the interest of SSC cannot be passed, but he has the wide powers to make such inquiry or cause such inquiry as it deems fit, my lord. So, my lord, kindly now refer to my lord, the third compilation, my lord, which I have furnished. Kindly refer to, my lord,
Yes, which one?
third compilation.
Hmm. Yes, which one?
Kindly refer to page number 4. Page 4, my lord.
Yes, at least.
Kindly refer to
Hmm.
paragraph 3. Officers of the department must not take advantage of the ignorance of an SSC as to his rights. It is one of their duties to assist a taxpayer in every reasonable way, particularly in the matter of claiming and securing reliefs. And in this regard, the officer should take the initiative in guiding a taxpayer where proceedings or other particulars before them indicate that some refund or relief is due to them. This attitude in long run benefit the department, for it could inspire confidence in him that he may be sure of getting a squared relief from the department. Although, therefore, the responsibility for claiming refunds and relief rests with the SSC on whom it is imposed by law, officers should draw their attention to any refunds or relief to which they appear to clearly entitled, but which they have omitted to claim for some reason or other. So even if I am omitted to claim some relief or refund, but if the officer feels that it is justifiable, irrespective of my error in the return, they should endeavor to grant me such relief and should rather guide me that this is what you should do to get this kind of a relief. Now, my lord, kindly refer to 2 or 3 judgments of the High Court. The first one is, my lord, the start Bombay High Court judgment, page 42, my lord. Page 42, my lord, kindly go to paragraph 8, where this circular has been quoted. This circular which I just read, so I am not reading it again. Paragraph 8, now paragraph 9, my lord. It is now well settled that even if the contents of a circular may amount to a deviation on a point of law, a circular of the Central Board of Revenue, which confers some benefit of the SSE, is binding on all officers concerned with the execution of the IT Act, and they must carry out their duties in the light of the circular. So, if, my lord, it is binding upon them. Then, my lord, kindly refer to the power under 264, my lord. Kindly refer to page 71, my lord. Page 71, my lord. This is a judgment of the Honorable Bombay High Court. Kindly refer to paragraph 6, my lord. Paragraph 6, page 73. Respondent number 1, however, rejected petitioner's application on merits because according to him, the SSE had sought a revision on some fact which was indisputably apparent from record. He also accepts that the SSE is claiming change in all the figures duly filled in by him in his verified IDR, as since the change was not only of the figures for deduction and tax credit, but also his gross total income and its breakup under various sets of income, the sanctity of IDR will be disturbed, and hence the new revised figures cannot be considered. According to respondent number 1, income of an SSE is dependent on the sources he had, heads under which it is assessed, special rate applicable if any, etc. Determination of income of any SSE is an exercise which involves group scrutiny and cannot be merely substituted by acceptance of income figure claimed by the SSE. Respondent number 1 says determination of total income of SSE cannot be the mandate of section 264. Then, my lord, a Delhi High Court judgment is referred to. Then, my lord, kindly go to the next paragraph. From the various judicial pronouncements, it is settled that the power conferred under section 264 of the Act is very wide. The commissioner is bound to apply his mind to the question whether the petitioner was taxable on that income. Since section 264 uses the expression any order, it would imply that the section does not limit the power to correct error committed by the subordinate authorities, but could even be exercised where errors are committed by the SSE. It could even cover situation where the SSE, because of error, has not put forth a legitimate claim at the time of filing of the return, and the error is subsequently discovered and is raised for the first time in an application under 264. Therefore, the power conferred under section 264 of the Act is very wide. In our view, the commissioner is duty bound to apply his mind to the application filed the SSE and pass such orders thereon. Section 264 of the Act also empowers respondent number 1 to call for record of any proceeding under the Act in which any order has been passed and make such inquiry or cause such inquiry to be made and pass such orders as he thinks fit. Therefore, if the respondent number feels that the detailed inquiry is necessary and he will be hard pressed for time, he may make such inquiry made by the assessing officer and direct the assessing officer to file a report. So, my lord, Delhi High Court and Bombay High Court both say that even if I suppose there is a circular also, then there are these two the judgments of Delhi High Court, Bombay High Court, which says that even if I have committed some error, but some relief is due to me, but the officer is duty bound to cause such inquiry as is necessary to grant me relief. Normally, here, their only contention is that my income has not accrued within the state of Mizoram. And how they have come to the conclusion without conducting any inquiry, man.
Yes.
Well, they have, well, my humble submission is, my learned friend's contention is that I committed some errors in filing of the return, so that is fatal. My only error was that I have, my lord, put that excess claim of the profit amount instead of the amount which was, my lord, the correct figure. But nevertheless, my lord, what is the premise of the officer concerned in the faceless assessing proceeding as well as under 264, my divisional application? Their contention is based upon the documents furnished by me and saying that you have not furnished enough documents, you have not furnished your purchase invoices, you have not furnished your sales invoices, so I am not able to verify whether at all you are conducting business from the state of Mizoram. But my submission is that the commissioner who was sitting in Shillong, I could not have transported 12,000 invoices to Shillong from Lunglei to Shillong. Secondly, all this voluminous document was not possible to upload on the portal when my original assessment was done. Therefore, it was necessary to at least semblance of inquiry should have been done. The commissioner under 264, he has wide powers I have shown, my lord. He can even correct the errors committed by me. Whether I am maintaining books of accounts or not, that they have come to conclusion, even though I have furnished detail, my lord, the debtor figure, creditor figure, my lord, all these figures, balance sheet, profit and loss account, but it is, my lord, anybody who deals with accountancy, my lord, knows that profit and loss account, balance sheet, all these figures cannot be, my lord, done without maintenance of the preliminary books of accounts. And in any 11, 12 books, how the profit and loss account is prepared, well, it will be evident that first I need to maintain journal entries, cash book, bank book, trial balance, only then I can prepare profit and loss account and balance sheet. And it is an acknowledged fact that I have submitted my profit and loss account and balance sheet in the course of assessment as well as before the officer exercising power under 264. So, my lord, this entire, my lord, the basis of assessing is on the presumption or assumption. My lord, I have, my lord, shown, my lord, that I have purchased, my lord, I have enclosed those invoices that all multinational companies have delivered goods to me in Mizoram. But how can it be presumed that all my goods were sold outside the state of Mizoram when they were delivered in Lunglei? They should have visited and inspected my premises, whether I am running any business or at all or not. They could have examined my stock, my books of accounts, everything. My humble submission is that this conclusion that 69A, number one, the SOCO's notice itself, my lord. Kindly see the SOCO's notice. Kindly refer to page 175. 175.
Yes, yes.
Paragraph 3.6. On perusal of the submission in respect of exemption claim under section 1026 of the Act, rupees 289.56, 255, the SAC has only submitted exemption certificate, ID proof number, bank statement, which did not prove from where the income actually generated. SAC is required to submit sales ledger, bills, invoices. The onus was on the SAC to prove the income arising from scheduled tribe area. SEC has not produced any concrete evidence to prove that the income was generated from Mizoram. Therefore, required to show cause why exemption claimed under 1026 of rupees 289.5625 should not be disallowed and added to the total income. So the proposal was only to disallow 289.56,255 There was no invocation of section 69A. And my lord, kindly see the assessment order. The amount which has been added, which starts from page 307. Kindly go to page 316, my lord. 316.
Yes, 316.
Therefore, the addition of rupees 29,85,052 is being made under section 69A of the Income Tax Act 1961, and tax on income shall be computed as per provision of section 115 BBE of the Act 1961. It is a fit case for initiating penalty proceeding under section 271 AAC, as the income of the SSC includes income under 69A of the Act. But this 69A does not find mention in so-called notice, my lord. And my lord, this addition of 29 crore, my lord, the proposed addition under so-called notice is only 2,89,000. This 29 crore was not what was proposed in the so-called notice, my lord. I've just shown, my lord, on page 177. Sorry, no, not 177.
175.
Sorry, 175. 175, the proposed addition is 289,56,255.
It's 28 lakhs, not 2 lakhs.
No,
I think it's 20.
2 crore 89 lakhs. The proposal is 2 crore 89 lakhs. And the addition which has been made is 29 crore. Under section 69A. Now the order does not say why section 69A has been invoked. What are the conditions of 69A? Now, will kindly refer to section 69A.
What is this addition of 29?
Yes, my lord.
Addition of 29, but this allowance.
Is my credits to my the amount deposited in my bank account. So entire amount which has been deposited in my bank account has been presumed to be my income.
Okay.
I have submitted a the judgment of the Honorable Supreme Court in the first occasion when I made my submission, that only income tax, under the Income Tax Act, only the profit element can be taxed, not my entire credits. But kindly see paragraph 4.4, how they have arrived at this figure.
4.4.
Paragraph 3,
4.5.
page 315, paragraph 4.4, 5.4. The reply furnished by the SSC had been perused carefully, but found untenable and bereft of any merit. As per reply of the SSC, she was engaged in the retail and wholesale distribution business of FMCG products in the name of style of agent trader, and part of cash deposits in bank accounts were cut off from the aforesaid business. With regard to such contention of the SSC, it is pertinent to mention here that total credit entries aggregates to rupees 29 crore 85,052, which also includes cash deposit of 23,10,84,723. Despite such huge value of financial transactions, the SSC failed to maintain the books of accounts, which is mandatory as envisaged under 44 AA of the Act, and also failed to get the books of accounts audited as prescribed under 44 AB. The SSC claimed in a reply that during the years she was engaged in retail and wholesale distribution of FMCG products, and entire income was accrued and arose in the state of Mizoram and claimed exemption under 1026 of the Act. Such contention of the SSC is not tenable due to lack of credible evidence. The SSC, in support of such claim, failed to furnish documentary evidence of purchase and sale of FMCG products, name and address of parties from whom SSCs made purchase, copies of bills, invoices in respect of purchase and sale of FMCG products, Likewise, SSC also failed to provide the details of the parties, their ledger account and cross confirmation to whom sales have been made. Therefore, in the absence of above detail and evidences, the claim of exemption under 1086 of the Act and income thereon deposit of cash in the bank account remained unverified. The SSC should have to furnish the aforesaid basic documentary requirement under the Income Tax Act to substantiate the claim of exemption under 1086 of the Act. Now, where is this requirement, my lord, that only if these documents are furnished, only then I am eligible to benefit under 1026. 1026 says that my income should accrue in the state of Mizoram. My lord, I have submitted all the documents which I could furnish. I have stated that I am conducting business. I have a wholesale and trading business in the Lunglei. My lord, the assessing of this entire assessment happened over faceless process. Faceless means, my lord, I cannot see the officer. Officer cannot see me. I have to upload all the documents in my reply on the income tax portal, and the assessment is conducted by. On the portal, my lord, all these voluminous documents, books of accounts, how it is, my lord, humanly possible for me to furnish them. It was impossible, my lord. And my lord, kindly refer to the basis of their initiation of this entire proceeding, my lord. One second. Kindly refer to page 173, man. Sorry. Yes, 173. Kindly refer to the paragraph just before the last paragraph. This is a so-called notice, man. How they initiated the proceeding. Thereafter, case of the SSC for assessment year 22-23 was selected under scrutiny through cash in order to verify the exemption claimed under section 1026. Cash deposited in bank account and turnover shown in IDR is lower in comparison to turnover shown in GSTR 9C written by the SSC. But so they have compared my income tax return with my GST return, and that was the basis of initiation of the proceeding. So, my lord, my submission is that all the details of the parties, my lord, the address and everything, my lord, it is available on the GSTN portal. My lord, what is the, my lord, the assessment order says that why they could not, my lord, come to the conclusion that I am doing business from the state of Mizoram is that I did not furnish my purchase and sale invoices, and they could not verify the details of the party. All these details, my lord, are available on the GSTN portal, my lord. Everything is available with them. So, my lord, there are two things. One is that they could have verified their own GSTN portal. And secondly, my lord, they should have verified my place of business before coming to the conclusion that, my lord, I am not doing business from the state of Mizoram. And my entire so-called notice, my lord, the entire order is beyond the so-called notice, and I will show, my lord, judgments of my lord, the Supreme Court that, my lord, the so-called notice, my lord, the order cannot be beyond so-called notice, my lord. Kindly refer to, my lord, the third compilation, my lord, which I have furnished, page 40.
No, in what way it is beyond the show cause notice?
My lord, because, my lord, in the so-called notice, I have just shown, my lord, page 175. Page 175, paragraph 3.6.
Exemption claim.
The proposed decision is that therefore required to show cause why the exemption claimed under 1026 of 2,89,56,255 should not be disallowed and added to the total income. This is the only proposal, my lord. There is no proposal to add it under section 69A number 1, and number 2, the amount is only 2,89. Now, my lord, kindly refer to the assessment order. Page 316.
Hmm.
The addition. Kindly see the amount of addition,
Before that, you had referred to page 174
174.
or 175.
Yes. On perusal of the reply and bank statement, it is seen that the total credit entries appearing in the three bank account, including cash deposit, come to rupees 29 crore, whereas as per return of income, total sales is 0. In view of this, you are required to show cause why this amount should not be treated as unexcluded income. Here it is pertinent to mention that even if your income is exempt under 20, you are required to maintain books of accounts as per provision of the Act.
So this is the ground, isn't it?
But my lord, they are in 3.6, they have so caused me only for finally 2 crore 89 lakh. That is my submission. There cannot be, my lord, dual, my lord, disallowance. They cannot add 289 as well as, my lord, 29 crore.
Okay, then come to page 316.
316.
So this is where 69A.
They 29 crore as well as 289.
Hmm.
But my entire credit is presumed to be my income, and then my profit which I claimed as under exempt under 1026, that is also my disallowed.
Hmm.
There cannot be multiple addition, my lord. Do not kindly refer to section 69A, my lord. Wherein any financial year, the assessee is found to be the owner of any money, bullion, jewelry or other valuable article, and such money, bullion, jewelry or other valuable article is not recorded in the books of accounts, if any maintained by him from any source of income, and the assessee offers no explanation about the nature and source of acquisition of money, bullion, jewelry or other valuable article, or the explanation offered by him is not in the officer satisfactory, the money and the value of the bullion, jewelry or other valuable article may be deemed to be the income of the assessee. So there are two things, my lord. One is that I am not maintaining books of accounts. And secondly, my lord, I should be the owner of money, bullion, jewelry or other valuable article which is not recorded in the books of account. But my first condition is not satisfied. But in the query, in the return, was whether I am liable to maintain books of account. And I said that I am not liable as per the Act. So it was whether I am mandated as per the law. So I have shown, my lord, under 44A, I am not mandated to maintain books of account. So my liability to maintain is not there. But nevertheless, I have maintained, my lord, because I am also filing my GSTR 9 return, which is an acknowledged fact. So GST returns I am filing. I have submitted my profit and loss books of account. I have given the details of the debtor, creditor, my lord, stock and cash balances. All these figures, my lord, I could not have provided without maintenance of books of account. And my lord, in the column for profit and loss account, I have not furnished those figures, because had I furnished that, it would have gone to the total income part. And I would have been liable to pay tax. So I had to necessarily keep considering the structure of the income tax return, where one figure gets auto-populated in the other column. So I reported my income, my profit part in the exempt income schedule instead of profit and loss account, so that it does not go to the total income part. And therefore, my lord, Accordingly, my returns were prepared. But nevertheless, my lord, I have maintained books of account. That is number one, my lord. Secondly, my lord, this time to time credits in the my lord, deposit in my bank account and my lord, payments to my various parties, which is undisputed. My GST returns are not disputed, my lord. My entire proceeding is on the basis of comparison of income tax and GST return. My GST return is not disputed, my lord. That is also falling within the purview of the Ministry of Finance. So had they doubted my GST or my lord, GST returns, they could have parallelly, my lord, investigated my GST inquiry that all your my reporting of purchase and sales are fake. So you are not entitled to input tax credit or not, my lord, your entire business is fake. That is nowhere disputed, my lord, in the GST. It is only with respect to income tax that my proceeding is initiated on the basis of GST return. The GST return is not disputed, but the reason has, they have come to the conclusion that I am not conducting any business from the state of Mizoram. Without, my lord, conducting any verification whatsoever at my place of business, that number one, I am not maintaining books of accounts. Number two, I am not conducting business. Nothing has been verified. It is all assumption and presumption, my lord. And on the first occasion, I have given number of Supreme Court judgments that under the Income Tax Act, on the basis of assumption and presumption, my lord, no addition can be made. So I have already given a written submission, my lord, and I have submitted that on the preponderance of probability, my lord. One has to look at the human probability, but whether it is possible that on a day-to-day basis, I am depositing huge amount of cash in my bank account, whether I am bringing it from, say, 300 kilometers away from a distant location which is outside the Mizoram to a branch, a village in Lunglei, on a daily basis, depositing, my lord, huge amount of cash, my lord. I had shown, my lord, the bank statement, my lord. So lordship my lord, desires, my lord, I can show it 1 second, my lord. The page 199, my lord. Page 199. Kindly see, on 3rd of April, I have deposited a case of 33,04,000. Then again on 3/4,
This is a printout of the bank statements
yes, my lord,
from
this is
the
a branch
MRB,
in Lunglei, my lord. Kindly see.
the rural bank.
Yes, my lord. Rural
Yes,
bank,
Mizoram Rural Bank. Yes.
So on a daily basis, my lord, this amount of cash twice a day sees my lord, almost twice a day. On every day, if your lordship sees this bank statement, twice a day she is depositing the money. So how she will bring my lord, the money from outside the state of Mizoram and on a daily basis, why she will deposit it in the Lunglei branch?
What do you say about the sharing an account with your sister?
Yes, my lord.
What do you say? What do you say about the sharing of account?
About sharing of the account, my lord, I submit that the law does not prohibit me to maintain a joint account. My learned friend has submitted that my lord, the law, my lord, Income Tax Act does not allow. He has not shown any provision which prohibit maintenance of joint bank account between family members. But I will show one judgment of the Honorable Supreme Court.
No, one thing, see, you may have joint account, like supposing even a spouse, husband,
ma'am.
wife, they have joint accounts.
Yes,
Names are there. Both can operate the account.
correct.
It is there. But here's a case where there's two different business. So for the purpose of
Ideally, she should not have done so. But nevertheless, she has herself disclosed this fact. It is not that they have discovered it. In her first reply itself to the initiation of the assessment proceeding, she has truthfully come out and stated that this is the state of affairs. It is not that it has been discovered by the IT department. And I have also given a.
No, it's nobody's case that was not disclosed, or you have disclosed it, no doubt. But things that doesn't it create a bit difficulty?
But I have, that is why, my lord, I have given a chartered accountant certificate, my lord. Kindly refer to page 388. I have given a chartered accountant certificate to give a breakup to
No.
overcome this difficulty.
How do we differentiate who has deposited this, how much, and who has deposited how much?
For that one, I have
Hmm.
given this certificate.
388.
380. But we have verified the records of LJ traders. So in so that the above stated as a sole proprietor business. The proprietor of the business is a local Mizo girl who belongs to Mizo community. That she is not required to pay income tax by virtue of 1026. That measure LJ trader is registered under GST law wide registration number so and so. That the above business has been in existence for last 15 years and was also registered under the Mizoram VAT Act and Central Sales Tax Act wide registration number so and so. That the business activities of the above concerned are trading into FMCG products, dairy products, tobacco products, edible and food items of reputed brands of India. That the business turnover derived from above stated business during the period and reported under GST and income tax was 16 crore 55,746 plus taxes thereon as per the GST return filed was CGST 1 crore 11 lakh 67,355, SGST 111 67,355 and cess 5 crore 73,02,705. Thus the total sales received including of taxes was 24 crore 54 lakh 93,163.73. That the main bank account of the aforesaid was aligned with the Mizoram Rural Bank, Lunglei branch, wherein the above business turnover is deposited. Along with the turnover of one LZ agency also deals in similar products and business is owned by proprietor sister, namely so and so, who is a separate GST nominable for a business but maintained a common bank account for both businesses. That the turnover of LJ agency for so and so as per the annual return was so and so plus taxes thereupon so and so. Thus the total sales received inclusive of taxes was 12 crore 88,39,661 and a total breakup is given. So they have not come up with any evidence to refute this CA certificate. Well, my humble submission is that in what happens in Maldives, then I'm telling you from my experience that in the state of Meghalaya, Mizoram, and all these northeastern states, thereby constitutionally, they are exempt from income tax if their income accrues in those particular state. But the level of the books of accounts or the professionals available to guide them are not there because they are not liable to pay tax. So that kind of guidance is not available. That too in a rural area, those kind of so maybe they should have maintained. Ideally speaking, on a the perfect the scenario, they should have maintained separate books of account. But she has come forward. She has herself stated the true state of affairs. She has given a CA certificate, and they have also reported their turnover. It is not that whatever I am stating, it is not matching with the GST turnover. It is matching with the GST turnover. So if the GST turnover in the total receipts are verified, they are tallied together, they will match. So it is not that it cannot be verified. It is unverifiable. Both the turnovers are reported turnover in the GST. What is the main issue? Both of them are exempt from income tax. What is the core issue? Whether the income arose in the state of Mizoram. That is the core issue. There is no dispute about that. She is a tribal from Mizoram. There is no other dispute. Only issue is whether her income has accrued or arose in the state of Mizoram. If that hurdle is crossed, everything else, it may become, it may be relevant, but they become largely academic. Suppose I am earning 100 crore rupees, 5 crore rupees, or 5 lakh rupees, or 5,000 crore rupees, but if my income is accruing or arising in the state of Mizoram, everything is exempt. And rest are all procedural infirmities, if at all. There is no, she could not have gained any advantage by doing all these things. Had it been a, say, matter of, say, Gauhati, where there is no such exemption line, then the greater scrutiny was required. But here the only the primary question which needs to be discovered is whether she is doing business from Lunglei or not. That aspect has not been examined. Whether she has maintained her books of accounts or not. That aspect has not been examined. Nobody has visited her premises to see whether she is having any business establishment, whether she is maintaining books of accounts. If suppose she is maintaining books of accounts, then 69A does not get attracted at all. And secondly, my lord, this time to time deposits, my lord, I have submitted, my lord, that judgment of the Honorable Supreme Court in the second volume, my lord. Kindly once more, my lord, kindly refer to that. Volume number 2. Judgment is starting at page 188.
It's on 69A.
Yes, my lord.
This is on 69A.
69A. Entire analysis of 69A. Kindly refer to, my lord, page 198. But I will read just paragraph 26.
Yes.
Section 69 and 69A, apart from being close neighbors, do bear resemblance with one another. Section 69 deals with unexplained investment. Section 69A deals with unexplained money, bullion, jewelry, or other valuable items. Section 69A was inserted by Amending Act of 64 and it came into effect with effect from 1964. Both sections require that the subject matter of the provisions, investment in the case of section 69 and money, bullion, jewelry, or other valuable article in 69A are not recorded in the books of accounts. That in a case where books of accounts are maintained. In the case of investment under section 69, and essentially the lawgiver contemplates the assessing officer finding that the assessee has made the investment. In the case of 69A, the assessee must be found to be the owner of the money, bullion, jewelry, or other valuable item. In both the cases, if the assessee is able to offer an explanation about the nature and source of investment etc., and it is not found unsatisfactory, there can be no deemed income. So, my lord, 27 say it breaks up the requirement. The assessee must be found to be the owner. He must be the owner of any money, bullion, jewelry, or other valuable article. And it must not be recorded in the books of accounts. I am repeatedly submitting that, my lord, my books of accounts were maintained. But nevertheless, it should satisfy the criteria of money, bullion, jewelry, or other valuable article. Now, what is the meaning of this, my lord? That has been explained, my lord, in subsequent paragraphs. But kindly refer to paragraph 77 on page 216.
Hmm. Yes.
Page paragraph 77, and this also distinguishes the judgment cited by my learned friend. So on the earlier occasion, my learned friend had submitted a Supreme Court judgment. This court has referred to the principle of eudem generis and nostri res sociis, which undoubtedly are roots of construction, the latter of being described as having treacherous underpinnings and the former requiring the existence of a genus, which is not exhausted by the categories in the statutes. This court has also referred to the definition of words money, bullion, valuable, and article. The court approves the view taken by the High Court of Gujarat in so and so that a document of title to immovable property or a fixed deposit receipt would not qualify as other valuable article. So fixed deposit receipt also, my lord. So money, my lord, fixed deposit receipt and money deposited in the bank account are of same genus, my lord. And the Honorable Supreme Court says that a title to immovable property or a fixed deposit receipt would not qualify as a valuable article. The reason which have been given appear to be sound. A document of title or a fixed deposit receipt would not be articles which can be bought and sold in the market. So here I have deposited money from time to time in my bank account and it has been withdrawn also, as would be evident from my bank statement. So if a fixed deposit receipt does not qualify to be an article, if it satisfies the requirement of 69A, then how can the money deposited from time to time in the bank, in a current bank account or a saving bank account can qualify the same yardstick? An article would not encompass an item movable property. This court can safely conclude that the article must be movable property. One strong indication that the principle of item generis may not apply is a decision of this court in Joharmal, where the articles involved were watches. Watches by no stretch of imagination can be brought in on the basis of item generis. They do not belong to the so-called genus of money or bullion or jewelry. The hallmark of a watch in the context of expression other valuable article would be that it is marketable and it has a value. When it comes to value, it is noticed that in the definition of the word valuable, it is defined as worth a good price having a financial or market value. The word valuable has been defined again as an adjective as meaning with a great deal of money in concise Oxford dictionary. Valuable therefore cannot be understood anything which has any value. The intention of lawgiver in introducing 69A was to get an income which has not been reflected in the books of accounts but found to belong to the SSE. Not only must belong to the SSE, it must be other valuable article. Let us consider a few examples. Let us take the case of an SSE which found to be the owner of 50 mobile phones each having a market value of 2 lakh rupees. The value of such article each having a price of 2 lakh would amount to a sum of 1 crore. Let us take another example where the SSE is found to be the owner of 25 highly expensive cameras. It would be said that having found a good price or worth a great deal of money, they would to the extent excluded from the purview of 69A. On the other hand, let us take an example where a person is found to be possession of 500 tender coconuts. They would have a value and even be marketable. It may be wholly inapposite to describe the 500 tender coconuts as valuable article. It goes both to the marketably, also to the fact it may not be described as worth a good price. Each case must be divided with respect to the facts as to which articles or movable worth a great deal of money or worth a good price are comprehend articles which may not command such a price must stand excluded from the ambit of other valuable articles. Then, my lord, this is a concrete judgment, my lord, of Honorable Justice Rishikesh Roy. Then kindly refer to paragraph 9, page 219. At this point, it may be useful to refer to circular number 20 of 64. In this circular, the Ministry of Finance, while defending insertion of 69, stated that the 9464 amendment is enacted not to subject lower middle class people to taxation by taxing gold or jewelry inherited from forefathers, but the provision is mandated for big SSEs who convert their black money and unaccounted wealth into gold jewelry and gold vessel and claim it to be heirloom. This makes it clear that the legislature never intended that any and every article of value should be brought within the ambit of 69A. It is only the high-priced precious items that command a premium price and are often used by wealthy individuals to park their unaccounted money by converting into gold and bullion that the 69A was inserted to address and to make such articles taxable under Income Tax Act. Therefore, the intent of legislature through the amendment was to subject articles like gold, jewelry and other valuable items to income tax where such articles were typically owned with the intention of avoiding tax. It is like, say, gold, jewelry and other valuable articles which is, my lord, not accounted in the books of account and found to be in possession. So the SSE must be found to be in possession of those articles. Not that the money is time to time deposited in the bank account and, my lord, withdrawn or spent. That will come within the purview of 69A. Conversely, if all sundry articles of nominal value are bracketed in the category of valuable article, it will lead to an uncertainty and it will be inconsistent with the legislative intent. Focusing on the high total value of article, ignoring its lower price, it would mean that low cost ordinary articles also in the valuable category under 69A. That would defy the legislature logic. In this context, when the principle of AUGM generis is applied, the preceding words in 69A such as money, bullion, jewelry would suggest that the phrase other valuable article which follows the word would justify inclusion of only high value goods. Any other way of reading the phrase other valuable article or valuable article by ignoring the kind of specific goods mentioned in the preceding part would be incorrect and would be violation to the plain language or the provision and will travel beyond the legislative intent. So my submission, my lord, is that there was a particular purpose of 69A only to tax the high value items which are sold at a premium. It is not intended, and even my lord, paragraph 77, I have shown that fixed deposit receipt would not fall within the purview of 69. Here, the money has been deposited from time to time in the bank account and withdrawn. So by no stretch of imagination, and I am not found to be in possession also, my lord. It is not that I am found to be in possession of the money which has been deposited from time to time. The balance, my lord, which is there on the page 306. Total amount which was lying on 31st March was 9,42,211. Only that much account was lying in my bank account. So all these total credits, my lord, from time to time would not have been taxed, my lord. And I have also, my lord, earlier occasion I have submitted this judgment, my lord. It was individually submitted. Lakshmi Machine Works. And I have submitted, my lord, paragraph 15 that we do not find merit in the above contention advanced. One single judgment was submitted.
What was the name of the party?
Sorry, it was, my lord, the Commissioner of Income Tax versus Lakshmi Machine Works. We do not find any merit in the above contentions advanced on behalf of the department. It is important to note that the tax, shall I read out?
Just a minute. I have not found a thing. Sluice. Anyway, you give me the citation.
Yes, madam.
Give me the citation.
But citation, I will submit this copy only, but
So you read, you have one, how many copies do you have?
doesn't matter, I will get.
You have one copy.
I have one copy, but kindly
So
just,
read it first then.
I will just read out. Paragraph 15.
Hmm.
We do not find any merit in the above contentions advanced on behalf of the department.
Yes.
It is important to note that the tax under the Act is upon income, profits and gain. It is not a tax on gross receipts. Under section 224 of the Act, word income includes profit and gains. The charge is not on gross receipts, but on profit and gains. The charge is not on gross receipts, but on profits and gains properly so called. Gross profit or sale profits, however, include profit.
Which paragraph you just read?
Paragraph, yes,
Hmm. Yes,
I will just then, summarize my submission.
you can wind up. I think we have heard.
I am just repeating myself, but I'll just summarize unnecessarily, I will not trouble you also. From my, I have submitted that the entire, the addition is on the basis of exemption and presumption.
Hmm.
No investigation has been done. The presumption is that income has not accrued. They have not adduced any single material mal. Nothing mal. Before coming to the conclusion that my income is not earned in the state of Mizoram. All that they are saying that you have not submitted your purchase invoices, sales invoices. But my non-furnishing of purchase and sale invoices does not absolve the officer concerned to conduct an adequate inquiry, proper inquiry, before arriving at this serious conclusion that I am not conducting business from the state of Mizoram, particularly when I am registered under the GST Act, I am regularly filing my GST returns, which are not disputed. And under 264, the officer had ample power, even if I have committed some error, and I am eligible to some benefit. Before one of the requirement of 264 is that the order prejudicial to the interest of the SSC should not be passed. Here, my lord, he has come just repeated the arguments of the assessing officer without my lord conducting any inquiry, whereas he is mandated under 264 to conduct inquiry before coming to his conclusion. He has not conducted any inquiry himself. He has just copy pasted the order of the assessing officer. There is no independent verification, nothing. Whatever assessing officer stated, my lord, kindly just have a look at, if your lordship wants 264 order, see a 1-page order, 342.
Yes.
342, my lord, kindly see. Just, my lord, repetition of what assessing officer has done, no inquiry, nothing. Now, I am not reading out, my lord.
Not required.
There is nothing, my lord, in the commissioner had very huge responsibility on his shoulders to conduct inquiry, my lord. 264 mandates that to conduct such inquiry. Where is any inquiry, man? There is nothing. And neither the assessing officer nor the commissioner 264 has adduced any material before coming to the conclusion that I am not a person earning my income from the state of Mizoram. And my lord, on the basis of my lord, one Supreme Court judgment which I have already, my lord, furnished on my last occasion, that my lord, the preponderance of human probability should be looked into. And in my case, considering my lord, the huge deposit of cash in the Lunglei branch, the delivery of goods at my premises, the only conclusion which can be reached is that I am doing business, my lord. A reasonable conclusion can only be that I am doing business from the Lunglei rather than from the outside the state of Mizoram. Then, my lord, I have submitted a judgment that there should be a human approach
Yes.
in the assessment. And, my lord, it is the duty of the officer. The Supreme Court judgment says it is the duty of the officer to make necessary visit. My lord, I have given all this in my written submission. To make a visit to the SSC's place of residence or business for the examination of books of accounts and evidence. The Supreme Court judgment says so. My lord, there is no such thing done in this particular case. Now, 69A could not have been invoked in this case.
All right.
But 69A could not have been invoked, my lord, because books of accounts are maintained, as well as, my lord, the other conditions are not satisfied. Then tax can be levied. My lord, then the principle of res judicata also there, but I have shown on the earlier occasion that on the previous years also I have deposited the similar amount of money, cash deposits, and I have been assessed. So there is no reason to deviate from the earlier rigor, my lord, the conclusions. Then, my lord, Yes, but this is all. Madam.
All right, right. Yes.
Will take only 5-10 minutes.
Yes,
That's
Mr.
already my functions, and I have also filed my return.
Hmm.
Not, it was argued that the so-called notice proposes to only disallow the exempted income.
Well, I will withdraw that submission. I have some confusion. I will withdraw that submission.
Lordship may, once again, your lordship may think page 175 of the 175 of the requisition, that's so-called position.
So, my lord, I am withdrawing, man.
Yes, yes, no, I like to point out to paragraph. Page 175. So this is so-called notice, my lord, must emphasize it was based on para 3.76. Lordship may see para 3.2 top.
Hmm.
Further, on perusal of the bank statement, it is seen that the cash deposit in your bank account is rupees 23 crore 10 lakh so and so. Since you have not furnished the cash book and source of cash deposit with documentary evidence, why it should not be treated as unexplained money credits within the meaning of IT Act. So it is part of the so-called notice, my lord, and the opportunity was provided to the associate to explain it. And my lord, next your lordship see para 3.4. As per 26 AS, you have carried out work with Manish Kumar Jhunjhunwala, but no income for this has been shown in your return of income. You are therefore requested to submit details of the work carried out with him, that is a copy of ledger account, bills, invoices, copy of aggregate done, if any, copy of bank statement highlighting the transaction. So, my lord, what was found, my lord, that some third parties has also made some payments to the accounts of the petitioner, my lord. That has to be verified, my lord. That was not disclosed, my lord.
What is,
In fact, my lord,
what is this AS abbreviation stands for?
my lord,
26.
That is the my lord, yes, statement, my lord.
26 AS.
Lot. That reflects, my lord, the
Oh.
TDS amount of the, my lord, SSC. If somebody makes payment to the SSC, then it will be reflected in the, my lord, total in form 26 AS. That is, suppose 90% has been paid and 10% TDS amount were reflected in the TDS.
I see.
Form
Okay.
26 AS.
Okay.
So in the 26 AS, it was found that some Jhunjhunwala has made payment. That was reflected. But that was not disclosed in her income tax return. And my lord, in the return, I'll show only one page, my lord. That is page lordship 70. Lordship. Let's see. Page 74, my lord. Page 74, the last of next para, clause C1. Have you deposited amount or aggregate of amount exceeding rupees 1 crore in one or more current accounts during the previous year? No. My lord, you may kindly mark it. So, my lord, subsequently, when Shogos notice was issued, when we detected 28 crore has been deposited, my lord. And my lord, in response to the Shogos notice, my lord, in her reply, my lord, she has stated, my lord, at page 178. Reply to the Shogos notice, my lord, lecture as. Remarks. Respected sir, madam, subject. Submitting response for notice served upon me under section 142(1) with due respect, I want to submit response for notice served on me under section 141 of the Income Tax Act 61. Further, I am to inform you that I am incubated resident of so-and-so Gujarat. As I did not have knowledge about income complications, I came to know from my friends that we are exempted from paying income tax, but we will required to file income tax return before due date. Therefore, I myself filed the RTI for assessment year 22-23 without knowledge of filing. Therefore, instead of exempted income of rupees 28 lakhs, I claimed wrongly to rupees 2 crore 89 lakhs, which was shown excess of rupees 2 crore 60,000. Therefore, I want to consult my taxation professional for further work. Therefore, I am requesting income tax officer to accept my error while filing income tax return. If possible, please grant permission for reassessment of return. Further, I want to confirm that my sister so-and-so also having a farm is named so-and-so. We both use the same bank account for depositing cash collected from our sales.
Therefore, cash deposited reported by bank is 33 crore, which is more than my sales reported as per GST return. So, my lord, when in the income tax return, my lord, it was shown as zero in her any bank account, my lord, during the 11 assessment year. So, my lord, it is a complete case of, my lord, willful misstatement, suppression of material facts, my lord, and concealment of total income for the purpose of wrongful gain, my lord. When, my lord, we found, my lord, the SSC has deposited large cash into her bank account, opportunity was provided, my lord, and therefore, my lord, she claimed, my lord, she is unaware of the provisions of the act. Whereas she filed the return for the purpose of claiming refund, and refund was accordingly allowed. And my lord, therefore, my lord, and in fact, my lord, against this return, there is a provision in the Income Tax Act, subsection 5 of section 139, that in case SSC finds any misstatement or, my lord, any error in the return, she may also file a revised return, my lord, by rectifying the said error. That was not done. So, my lord, after going all through this, my lord, show cause notice was issued, my lord, opportunity was provided, my lord, and in response, my lord, she has said only this month, my lord, she is maintain, my lord, lordship, the books of accounts, my lord, under section 4A mandatory. And also, my lord, digital books of accounts, my lord, that is under section 4A, those are mandatory. And, my lord, those sections, my lord, speak there, my lord, if the sales, it refers to, my lord, my lord, receipts, my lord, it doesn't refer to any income, my lord. If receipts is, my lord, above the threshold limit, my lord, then that is mandatorily, my lord, mandatory, my lord, for SSC to maintain those documents. So, my lord, whether that my lord, threshold limit has been exceeds or not, my lord, that cannot be decided under 226, my lord. And moreover, my lord, against the assessment order, they have not prepared any appeal for the appellant. And so far as the submission of the SSC, my lord, regarding the wide power of section, my lord, 64, that is the reviewing authority, my lord. Your lordship may see, my lord, page 337, that is the notice issued, my lord, after the, my lord, this revision application was filed. Page 337. Even, my lord, after filing the revision application, my lord, this notice was issued, my lord, giving the SSC an ample opportunity to submit her case. Notice for hearing, page 337.
Yes.
So and so, subject notice of hearing in respect of return. So in this regard, a hearing in the matter is fixed on so and so every month. You are requested to attend in person or through an authorized representative to submit your representation, if any, along with supporting documents, information in support of the issues involved, as mentioned below. If you wish that the revision proceedings be conducted on the basis of your written submission representation, file in this office on or before the said due date, then your personal attendance is not required. You also have to option to file your submission from the e-filing portal using the link so. Required the following details to be produced on the hearing date over and above the submissions of the SSC like to make. Copy of the bank statement so these things were required to file. And my lord, what was the response? Your lordship, see page, my lord. A response to the, my lord, said notice at page 341. To the, my lord, the revisional authority. Response. Respected sir, in response to your notice, I would like to state that in my application for revision, I have stated that I am from a remote place of Lunglai, Mizoram, and I do not have any knowledge of taxation law, and moreover, there is any professional practitioners to help me in this regard. Therefore, sir, considering the facts, I would like to try to the submissions made in the revision application, and I do not have any other facts and figures to bring for your kind perusal. Therefore, sir, I once again request you to kind enough to me to accept the fact and that I have placed in my revision application and to do the needful so that I am exempted from payment of tax and penalty imposed on me and waive the proceeding. Third, to this act of kindness and shall remain be grateful to you. So, my lord, opportunity was provided, my lord, and she has said she has nothing to submit more than the application, my lord. And whatever argument was made, my lord, that the wide power cast upon the regional authority, my lord. So, my lord, all opportunity was provided to the my lord petitioner, my lord. And my lord, the fact that she is having, my lord, the 12,000 pages voluminous documents, my lord, all those things cannot be carried from Lunglai to Shillong, my lord. It was never been pleaded, my lord. Only response is this, my lord, during the course of revisional proceeding. And therefore, my lord, after going through the same, my lord, the revision order was passed, my lord. And my lord, show cause notice itself disclosed, my lord, the actions to be initiated, my lord. And therefore, my lord, my lord, assessing authority as well as the regional authority, my lord, those are, my lord, well being the, my lord, purview of the provisions under the act, my lord. And my lord, so far as, my lord, submissions of section 1026, my lord, my humble submission. 1026 is in, my lord, exemption to the, my lord, specified class of people, my lord. That 1026 is not provide any immunity under the act. It's only an exemption. Under section 10, there are 50 subsections, and 26 is one of such 50 subsections. To claim refund, my lord, one has to first file her return of income, my lord, by stating, my lord, truly and, my lord, correct, my lord, the statement, the proper, my lord, the actual transaction. Here, my lord, it is a clear case of, my lord, willful misstatement, my lord, concealment of, my lord, receipts, my lord, large scale, my lord, cash deposit into the bank's account. My lord. So, my lord, enough opportunity was provided, my lord. In spite of that, my lord, nothing was furnished, my lord. And in fact, my lord, she has not preferred the appeal before the appellate authority, who would be the, my lord, appropriate authority to consider all these things, my lord, which are based on, my lord, facts and figures. And under 226, my lord, certainly your lordship will not examine, my lord, whether the amount which reaches, my lord, the threshold limit, my lord, whether the case fall under section 44A. So this is my humble submission, my lord. Petition may be, my lord, dismissed, my lord, and my lord, my legal submission may be. That is my humble.
What is the provision for appeal?
My lord, with respect to appeal, my lord, I will just submit, my lord. I have two judgments, my lord. I have not submitted on that, my lord. That appellate remedy, expect, my lord, my learned friend. did not
Section?
argue. 246. So, my lord, I'll just point out, my lord.
Lord, appeal is 246A. That is appeal before the commissioner appeal. All these issues cannot consider, my lord, whether, my lord, the threshold limit has been exceeded or not. My lord, no, my lord, it's a clear case of, my lord, escapement, concealment.
The present case, the impugn orders passed under this 264. Is it an appealable order?
264 is not an appealable order.
Not an appealable order, against the order assessment order.
Again, the assessment order. So instead of filing appeal, he preferred 264. She preferred 264.
Just for the judgment.
And against 264, there is no appeal now.
No.
The
Again,
only remedy is only writ petition.
only petition, my lord. I will just follow it quickly, my lord. I'll address this.
Just a minute. Mr. Chetia, you have finished? Okay.
Kindly refer to, my lord, page 305 of my second, my lord, volume. 305. But the judgment starts from page 298.
Mm. Three
305.
Yes. Which para?
Para 27.
Mm.
Thus, the assessee can invoke the provision of 264 of the IT Act only after the time for filing the appeal is expired or after waiving his right of appeal. Section 264 of the IT Act is an alternative remedy available to the petitioner assessee who does not want to avail remedy by way of appeal. Thus, remedy available under 264 of the Act is an alternate remedy and not an additional remedy, and the assessee is not permitted to pursue both the remedies either simultaneously or one after another. So, I can either avail 264 or appellate remedy under 246A. I chose 264, my lord, because the power under 264 is greater. It is a, my lord, it is the power to even inquire. Rather he is mandated to inquire the true state of affair. That is why the SSC Bill 264. Now, my lord, kindly come to the judgment of the, my lord, the Delhi High Court. Sorry. Yes, Madras High Court. No. Page 280, Madras High Court, page 280. Judgment starts at 280. Kindly go to page 291, paragraph 24. Paragraph 220, 291, paragraph 20. It is contended by the learned counsel for the respondent that the order passed under 264, since not being an order prejudicial to the SSC, he is not entitled to the challenge same before this court. He invited this court's attention to section 264 of the Act, stipulating that the principal commissioner or commissioner may pass such order not being an order prejudicial to the SSC as he thinks fits. I am not convinced on the above objection raised by the revenue. No doubt explanation 1 of the section 7 of the 264 contemplates that an order by the principal commissioner or commissioner declined to interfere shall, for the purpose of 264, be deemed not to be an order prejudicial to the SSC. But that does not mean that even though the authority under 264 rejected the revision, thereby declining to interfere with the order put to challenge in revision, the aggrieved SSC cannot have any further remedy at all against the said order made under 264. There is no dispute to the fact that against an order made under 264, no further statutory appellate remedy is available to the aggrieved party. Therefore, it leads to an irrefutable conclusion that under the circumstances, a remedy under 226 of the Constitution of India is always available to the aggrieved party to challenge the order made under 264. So that is the only remedy available with court.
Okay.
My lord, with respect to my lord, my learned friend submission that I could have, my lord, revised my returns. But I have already stated in my written submission, so I will just not bother, my lord, trouble your lordship again. I should have made that submission on the earlier occasion. But my lord, my time limit to file the revision of the return had already expired. It can only be filed within 31st December of the assessment year. And this proceeding by the the assessment proceeding commenced after 31st December 2000. So 23. So 22, sorry. The assessment year is 22-23. The proceeding initiated after that month. So therefore, my lord, I could not have corrected, even if I discovered the mistake. In any case, I did not discover the mistakes, whatever errors are there in the return on my own. It was only pointed out in the so-called notice. And I had no occasion to, the time limit to file revised return had expired by then. And my lord, I have already submitted that, my lord, even if I have committed some error, under 264, the officer concerned had ample power to consider everything, to make fresh inquiry and come to a conclusion. And the endeavor should be to grant relief which is available to the SSC rather than the adversarial to the assessing officer is not adversarial to me. The endeavor should be to try to find out a way to grant me relief rather than to reject it.
All right.
Grateful.
Consider as necessary orders. Heard Mr. Vinay Kumar Sharaf, learned counsel for the petitioner. And Mr. S. Chetia, learned standing counsel, Income Tax Department, for respondent numbers 2 to 5. Anybody else appearing? Hearing concluded, judgment reserved. Oh, Ms. Zainab Sangpu is there. You're on mute.
My lord, I'm for the respondent number one. I'm,
Okay,
Am
right.
I
Also
able-
heard Ms. Zaram Sampul and at CGC, appearing for respondent number one.
yes. My lord,
Anybody
no
else
relief
besides
has
you?
been claimed. No relief
uh,
has been claimed against Ministry of
Okay,
Finance.
anybody else besides you?
No, my lord.
Government is there or? No, okay.